You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is McMillan versus the state of Florida.
Thank you, Your Honor. May it please the court, my name is Na Kerry and I'm representing Mr. McMillan.
Could you speak up a little bit?
A
little problem.
How's that?
That's better.
Okay. Mr. McMillan was sentenced to death for the murder of Danielle Stubs in Jacksonville, Florida. And we raised 3 issues in the brief. I'd like to focus on 2 of those today, the first and the third. And before we get into the argument, I'd like to just give a brief recap of the facts so that we're all on the same page. Justin McMillan had been dating the victim, Danielle Stubs, for about 8 months. He met her in the spring of 2008. He'd just gotten back from he was a civilian employee in Iraq and Afghanistan for 2.5 years. He'd just gotten back. He had separated from his wife in Georgia. He had 2 small kids, and they began dating. They dated for 8 months. By all accounts, they had a loving, close relationship. There was no indication of any type of difficulties between them. He was close to her family, spent vacations with her family, and so forth. They were both Navy families. The week before she was killed, she moved into another apartment. He helped her, along with her family, move into that townhouse. She was killed early Sunday morning. And that Friday, during the move, he went to lunch with her and her mother. And her mother testified at trial that he told her at that point that they were breaking up, that she was done with the relationship. He said he was moving back to Georgia to see about his kids. And he also indicated at some points that he was heading back to Iraq in the next month or so.
Just as far as what he testified to, I thought, did he say he was breaking up with her? I mean, she was at the lunch, the victim.
She was there.
Was she invited? I mean, it was her thank you lunch. Yes,
they were all there. It's not clear whether she was present during this conversation with the mother. The mother testified.
The point is, I don't know if that it sounded to me, I guess, and we could look exactly how it was said, is that he was leaving her to go back to Georgia and then to Iraq rather than she was dumping him.
It's not clear. There's some indication that she was ending it, but she was ending it because he was leaving. She wanted to get married. He was leaving. He had his kids to deal with, so that's not clear. We don't really have her testimony about that, obviously.
But you're not saying, I mean, was there any indication from the record that he was emotionally upset about?
No.
Okay,
there's no indication that he was angry or upset about the breakup.
And he wasn't upset about her going out with this other man and having sex with him?
That comes later. Okay, we're still at Friday. If I could just go through the timeline a little bit. Saturday he goes to the races. I'm going to get there really quick. He goes to the races. She goes out Saturday night with some friends, work friends. He's with his sister and then his sister and brother. This is like 2-3 a.m. She's with her work friends. He's with his sister and brother. She has sex with this other man, a friend of hers, that night. He drops her off. She's intoxicated, so he gives her a ride home. And he drops her off sometime 3:30, 3:45, somewhere in there, a.m. Okay? And his car is at the townhouse when this Morris drops her off. Okay? And then that's when the murder occurs.
Was he already inside the townhouse? Because I thought there was no indication that they saw someone in the in his car. And so was he in the townhouse, although he said he didn't have a key?
Well, we don't know. We don't know because I can tell you what he said, what his statements are. When Morris dropped him off, he didn't see anybody in the car, didn't see anybody standing around the car. He drops her off. She walks up to the door by his car and waves goodbye. You know, she obviously sees that her boyfriend or ex-boyfriend's car is there. Now, he testifies that he's in the car when she's dropped off and that he opens his door, they have a conversation, they go inside, they have sex, they go upstairs, and there's some sort of heated confrontation. He says he lost it.
Well, let's go. He, you've been using a lot of he's.
Justin.
Because the
defendant.
The person that drops him off sees the vehicles
yes.
there. The defendant gives How many different versions of what happened?
He gives a version of what happened to the police. There's the shootout, of course, and he's in the hospital for 2 weeks in a coma. This happens 2 days after the murder. The day he gets removed from ICU, the police go in and question him. And that statement, he initially denies it, and then he says yes. And he says he went in, he was in the car, she came home, they go inside, they have sex downstairs, they go upstairs. He says he lost it. He shot her while she was on the bed. He shot her once, and she rolled, and he shot her again. That's what he says. He wanted to take his life, but he couldn't. That's what he says in the hospital.
But I guess I'm assuming this is all going to whether the jury found premeditated murder.
Yes.
That you're saying there wasn't enough here to establish premeditation?
That's correct. I mean, our position is that based on the facts we have, there's a reasonable hypothesis that they were upstairs, there was a heated confrontation, either because they were talking about this man she'd been sleeping with. He found out she was sleeping with another man, and he lost it out of jealousy, rage, I don't know, feelings of abandonment. He obviously, I mean, Dr. Corp testified that...
Well, let's just go over this. Yeah. He shot her.
Yes.
Whether they had sex before, whether they had the heated confrontation downstairs or upstairs, the gun, he had to get the gun.
Yes.
From wherever, I mean, or either he had it with him.
Yes.
And then how did he shoot her?
He either had it with him or it was on the dresser, but he carried a gun.
And how was she shot?
Well, she was in the bed when she was shot the first time.
She was face down or was she face up?
She was found beside the bed.
But I guess I guess here's my problem.
Yes.
With your argument, you're a very experienced appellate attorney, and you always bring interesting issues to us. But I don't see, this isn't even close to like a domestic disturbance, that there's not enough for premeditated murder. I don't think they found CCP here. We're not talking about heightened premeditation.
Right.
And that may be good argument, I think, if you said the CCP isn't justified. But for the life of me, I can't see how, with premeditation and the instruction that it can be, the intent can be formed, moments before, that this isn't a premeditated murder.
Well, he says he lost it. He reacted. We've got several cases where it was a.
But again, why does the jury have? I thought, and you, what's the statement that he gives that's the least favorable to him that the jury would have heard, other than just that he somehow lost it and the gun happens just to be there, and he doesn't say it's discharged accidentally.
Well,
he doesn't say they were in a fight. He doesn't say that she was clawing at him.
He says it was a heated. Yeah, it was a heated discussion. He grabbed the gun and he just fired in reaction. It was a reflexive reaction. Premeditation requires conscious formation of an intent to kill.
In the statement he gave at the hospital, the tape statement that was played to the jury, in that statement, did he not say that it was not out of anger, they were not arguing, they were not fighting?
I don't believe so.
Didn't he say that? Because that would be an inconsistent statement to his position at the trial.
I do not recall him saying. He did in his trial testimony say, well, he wasn't angry. He was, he reacted. He was confused.
In his confession, McMillan stated that he and Stubs were not arguing and were not fighting after she got home.
Well, after she got home, correct. But then there's what happened upstairs. The statement at the hospital was very brief. His responses were monosyllabic. There were a lot of inaudibles. He said very little in that statement. I mean, I have it summarized here, and what I have is he said he lost it. He shot her while she was on the bed. He just lost it. He doesn't really say what happened, nor do they ask him
But doesn't he make a statement, though, at some point about the fact that she had an abortion or something?
Yes, at trial he testifies that they're upstairs, he gets dressed, they're getting ready to leave. He says a couple of times, and he says this to Dr. Kroc, too, who testified in the penalty phase, that she was upset with him because he was leaving. And he says that she says, I knew you were leaving anyway, so I killed your child. And he says that was what he reacted to.
Now, isn't the first time he said anything about that at trial?
Yes.
In all these discussions and all the various stories he told of the police prior to that, there was no mention of that.
Well, there was only one other time he spoke to the police where he admitted doing this, and that was in the hospital right after he got out of the ICU. That was the only one. He tried to deny it a couple of times, but that was the only time he fleshed out what was going on upstairs.
And he said, as I recall, that she showed him a receipt. Was there any actual receipt or anything that demonstrated
there was a receipt,
that?
Yeah, introduced at trial that she had been to an abortion clinic. Yes.
And his testimony obviously came after that receipt was introduced into evidence. But he knew about the receipt from the proceedings at trial. I'm
not sure when that was introduced, Your Honor. I don't recall. That may have come in during the state's rebuttal. I'm sure it's in the brief, but I don't recall. Yeah. So our position is that it was a reflexive shooting. He fired at the bed. He even testified the room was dark. We don't know if the room was dark. The room could have been dark.
After the first shot, though, she rolled over and was on the floor, and so then he had to shoot her again once she was on the floor.
He shot her a second time after or as she was rolling off the bed. He said she rolled off the bed. The second shot hit her in the top of the head. The medical examiner testified right here at the top. Part of the bullet exited. The other bullet went across just through the very top of her head. So it's not a situation where he's standing over and he's firing right into her head. There's no evidence of that. There's no indication that he moved after he fired the first shot.
I guess the problem of the reflexive idea, obviously he shot her because he got upset with her. I mean, he wasn't doing it for money. So that's not
right.
Either he got upset because she had sex that evening or whatever it was. And the idea that two people who have had a relationship could get upset with one another is nothing out of the ordinary. The issue I still have is that she's either, according to him, sleeping in the bed or in the bed. So he has to get the gun. And I don't see how with having to get the gun is then I lost it after I got the gun. You see that's what's not making sense in what you're saying.
Well, he testifies that, he carries a gun with him. He's going to Georgia. He was with his brother and sister. He was happy. He was normal. This was like an hour before this happened. He told them he's going to Georgia to see about his kids. He carries a gun with him.
I appreciate it might have it with him, but under his scenario, they had sex. So I assume he didn't have sex with his gun tied to him. In other words, he had to get the gun.
He says the gun is sitting on the TV stand right in front of the bed. And he's in the bathroom. He gets dressed. He gets the gun. He's getting ready to leave. And that's when they have the confrontation. That's when she says what she says. And that's when he loses it.
He said she was sleeping.
What?
I thought she was in the bed sleeping.
Well, in his trial testimony, he says, no, that's when she says...
But you see, the problem is, he gives 4 different versions. Mm-hmm. The jury makes the credibility determination as to what version is correct. And you're saying there's not enough evidence for the jury to find this was premeditated, which means just that, what does the jury instruction say? Moments before, or all you have to have is this fully formed intent at the time you
fully formed conscious purpose to kill.
Right.
Right.
And clearly he, with the gun, the gun just didn't go off accidentally, even under any of his 4 versions.
That's
and
correct.
They weren't in a fight with the gun. In other words, that she had the gun and he's trying to get it from her. We don't have that version.
That's correct, Your Honor, but the evidence have to exclude any possibility that this was a spur-of-the-moment reflexive shooting without thought.
Wasn't the first shot in the arm?
Yes.
And then the second shot was in the head?
Yes, as she's rolling off the bed.
Isn't that enough time to form some premeditation?
Well, it's a semi-automatic, 2 rapid shots, boom, boom. He's not thinking when he grabs the gun. He's not thinking when he fires the first shot. He's not thinking when he fires the second shot.
What about the third shot?
But that business about not thinking, that's just an assertion. I mean, you're saying he's not thinking. I mean... That's
a reasonable hypothesis of
now,
what happened here. Given what we know about this man, he has an IQ of 76. The trial judge found he was under mental and emotional distress at the time this happened. There wasn't any indication of animosity towards her. Which makes
it evil. I mean, if there's no animosity, why? Why do this? If there's no animosity between them, I thought your argument really was that there was some kind of, based on the fact that she said she had aborted the child or she had sex with someone else that's the very same night. So
at that moment, and what I'm suggesting is that there was no pre-planning. There was no indication that he was angry at her or contemplated hurting her until the moment he grabbed the gun.
You don't have to plan to do it for a long time to have premeditation. It can be, a minute or...
Okay. Well, the jury rejected the state's theory that this was a burglary, that there was a sexual battery, that he broke in and all this stuff. The state rejected all of that. So to some degree, they must have believed his version or some of his versions of what occurred, that there was some kind of emotion-fueled encounter. And it's our position that the evidence does not exclude that.
But the fact that he got mad with her and shot her doesn't mean that it was not premeditated. I mean, there's all kind of cases where people get mad and act on the anger, and it's premeditated.
It doesn't mean it wasn't premeditated, but it also doesn't mean that it was. I mean, I've cited several cases here where, I think in Green, the woman was shot in the head and she was battered and she was strangled, and the court said there's not sufficient evidence of premeditation.
But what you've got to convince us of is that no reasonable jury could decide that this was premeditated beyond a reasonable doubt. Isn't that what you've got to show?
No, I think I have to show that the state's evidence does not exclude that this homicide could have been committed without any premeditation. And I don't think the state's evidence does that.
Is Green what's your best case where you would say, based on that case, the court and this evidence, the court would have to find insufficient evidence of premeditated murder?
Well,
now Green, somehow, I look back on Green, I just don't think Green is going to be your best case. Do you think, is that your best case?
I don't know if that's our best case, but I think that demonstrates to some degree my point is that we don't know what happened here. We don't know what happened. And if you look at Green and you also look at Mungin and Jackson, and those were shootings, and they were reflexive shootings, and the court said there's no evidence of premeditation there. And then you look at Green, and Green again, there was... in Green, the defendant had even talked about killing her. But because the court didn't know exactly what happened at the time of her death... I guess
that's the thing. We know about what happened. We don't know which version of his is the most credible. And it may be that because there were phone calls, right, about she called him at 4:08 a.m. It was a 2-second call to his cell phone. He had called from a payphone and made 2 calls to her. So we know there may have been some attempts, and if she saw him, she may have let him in, and I guess the jury found that he didn't break in. So we got that. Maybe there was consensual sex. Maybe there wasn't. I guess that's why the jury rejected any kind of attempted sexual battery. But at some point we know that if there was a fight and he lost it, he had to go get the gun. And as Justice Polston said, I think, and Justice Quince, the compelling thing is the first shot is in the arm. But then there had to be a second shot right in her head. And that, and again, the formed intent can be, I don't know if it says seconds or a minute, but it's a fully formed intent prior to the shooting.
Yes, a fully formed purpose to kill her.
Well, shooting someone in the head is about as close to intending to shoot somebody. It's not like he shot her in the foot and then somehow she bled to death because it had gone off in the foot. I mean, the head.
Well, Mungin and Jackson shot the victims in the head and in the chest, point blank. And the court said that's not enough because if it's reflexive, if it's a reaction, there's not necessarily a thinking process. There's not necessarily a purpose to kill. It's just, and the gun was right there, either in his waistband or sitting on the counter. If he grabbed it, I think you have to assume that what's going on in his head is fury, anger, emotion. And when those feelings are in someone's brain, they're not thinking. It's not like us standing here talking about this. This is a man who has an IQ of 76. He has emotional deficits. He has brain damage.
Was Green, are you talking about the Green from 1998? Where there was a multiple stabbing?
Yes.
And there wasn't a gunshot. Well, your brief says that.
Yeah, stab wounds and strangled.
We did, and her legs were spread apart in the middle of an intersection.
That's correct. She was stabbed numerous times in blunt trauma, but she was also strangled, which obviously takes some time. Norton was found face down in an open field with a gunshot wound in the back of her head. That's another one where court said there were no prior difficulties. We just don't know what happened except that she was shot in the back of the head. So
no prior difficulties, but isn't by his own statement that he was either, there was something that he heard, he said about the abortion or the sex, that showed there was, you don't have to have difficulties in the weeks before, that he was coming there, he saw she wasn't home, and he was probably PO'd. Where was she? He had just helped her move in, and now she's out with her friends.
Right, that's part of our argument, that this was an emotion-fueled, sudden reflexive reaction.
I think that we probably heard that part of your argument and either going to accept it or not.
Yes, I agree. So let's move on to proportionality. I know the court's aware the death penalties reserved most aggravated, least mitigated. And it's our position that neither of those apply here. Of course, the most serious aggravator found in this case was the attempted second-degree murder. The jury found him guilty of that. That happened 2 days after he killed Ms. Stubs in the shootout with the police.
That's a pretty serious felony, what happened. I mean, if you just took this case and nothing else, and that he's on felony probation and he's under emotional distress, you got one thing. But doesn't the complexion change when he is about to be caught and he comes out shooting and he attempts to murder a police officer?
I agree that it's a serious aggravator. I think there's some circumstances the court needs to consider, though. He did return to Jacksonville. He didn't go to the police station like he said he would, but he came back to Jacksonville apparently to face what he'd done. His father testified that he called the detective and said, "I will bring him in." The detective said he never got that call, and the father said, "Well, I may have talked to a different detective." He was at his aunt's house. He wasn't hiding. He also didn't run when the police were behind him. There's some conflicting tests. The detective said they were behind him with the lights on for 1/10 of a mile.
Well, he didn't run because he intended to kill him?
I don't think so, Your Honor. And the jury found him guilty only of second-degree murder, reckless disregard, not intent to kill. He fired 2 shots at the police car, and he was shot 7 times. It was an impulsive reaction.
Well, the people in the car started running when he stopped the car, right? Clearly they knew something was about to go down.
His passengers got out. There 5 cars pulled up, 5 police cars pulled up. He did get out shooting. But I think the point is this was an impulsive reaction. I think the court has to view it as part of what happened 2 days early. He was still under emotional strain and stress of what he'd just done, which is kill the person he loved more than anyone in the world. Maybe he had hoped they would shoot him. I mean, Dr. Kropp testified, he did some destructive things. He may have been hoping they would shoot him. He did say...
Counsel, you can continue. I just want to let you know you're now down to a total of 3 minutes, so you're into your rebuttal.
Does that include my rebuttal?
It does.
Okay, I'll finish. I'll give a couple more minutes now then. So we do have the serious aggravator, but
Well, that means you'll have 1 minute left. Just want to make clear, we're communicating here.
Yes.
You're in your rebuttal time. You have a total of 2 minutes and 44 seconds.
Okay, with that, I'll sit down. Thank you, Your Honor.
Please, the court, Steve White with the Attorney General's Office representing Appalachia.
Can I just want to go to something in the judge's sentencing order, and you tell me if this evidence was evidence the jury heard. It's on page 4 and 5 of the sentencing order. There was evidence of a struggle. 3 of the blinds from the sliding glass door were torn off the track and were on the floor. Some of Danielle Stubs' clothing was found downstairs. Upstairs, police discovered a live round on the floor near Danielle Stubbs' bedroom door. 2 cartridge casings were found near Danielle Stubbs' body, and a fired bullet was found on her bed. The physical evidence indicated that Danielle Stubbs had been shot in the arm while she was laying on the bed. After being shot in the arm, Danielle Stubbs grabbed the comforter and moved to the floor on the side of the bed. While cowering on the floor trying to protect herself, the defendant moved towards her and shot the Danielle Stubbs in the head. Is that the part about that she didn't just fall off of the bed as if she had been shot, but that she actually moved to try to protect herself? Is there evidence of that in the record?
Absolutely, Your Honor. And of course, the state is entitled to all the facts and favorable inferences that support the verdict.
Well, it seems to me if we just have that, we have ample evidence.
Absolutely. If the court looks at the photographs, the color photographs of the crime scene, it is absolutely clear that Danielle Stubbs was shot as you faced from the foot of the bed towards the front of the bed, that is from the doorway. She was shot on the left side of the bed. In fact, that's where the projectile was recovered that went through her arm. Then there is substantial blood, a blood trail with substantial blood going from the left side of the bed to the right side of the bed, and blood spatter on the wall just off the bed. And then Miss Stubbs is found, Danielle Stubbs is found kneeling on the floor, 3/4 of the way turned around also. So she not only rolled out of bed, got on the floor, got on her knees, but she also had turned around when he shot her the next time in the head. So the photographs tell it all. There is no doubt whatsoever that he fired once, and that first shot went through the quilt, the comforter, and through her arm, landed on the bed. The police recovered it there on that left side of the bed. and there's no doubt whatsoever that she then rolled out of bed, turned partially around, and while she was kneeling on the floor, he basically executed her as she knelt there.
Now, the jury it was a special verdict that had both felony murder and premeditated. Was it two choices?
Yes, Your Honor.
So they actually specifically chose premeditated murder and rejected the state's theory of either a burglary or a sexual battery.
Well, they didn't find it, so yes, ma'am. But this also, I would also point out that the crime scene evidence in the upstairs bedroom comports with his statement to Detective Walcott at Shands on January 29th. And there the defendants told Detective Walcott, I shot her while she was in the bed, she rolled out of the bed, and then while she was on the floor, I shot her again.
Now, what would the part where there's a struggle downstairs and where some of her clothing is found downstairs, how did the state weave that evidence in terms of presenting that to the jury?
At some point before she was shot, there was a struggle. We know she's alive, as Your Honor has already pointed out. She was alive a little after 4 a.m., and we know that his car was there by his own testimony. He was sitting in his car at 3:30, so we know he didn't get inside, stay inside from 3:30 to a little after 4. We have him on the surveillance tape a little after 4 at the gas station. But at some point there was a struggle downstairs.
So he would have. His car was there though when Morris dropped Stubs off.
His car was there
and
at the townhouse.
And what time would that have been?
Pardon me?
What time?
That was about 3:30. We have a McDonald's receipt that indicates that just before that, 3:30 something. The last digit is blurred out. 3:30 something, they got the food at McDonald's, and that was right before he arrived at the Pine Verde townhouse. And Alan Morse testified it was about 3:30.
So his vehicle's there. So did he then leave to go to the payphone to call her?
Well, we know that he's not in the apartment at around 4:00. Surveillance videos 4:04 a.m. He is at the Gate store. I think it's about a quarter of a mile to eighth of a mile away at 4:04 a.m. So he's at the Gate store after she comes home. So at some point, we also know there was a struggle. I mean, we have an opposing counsel basically attacks each aspect of the struggle, but you put this package together, you know, the bloody substance under her fingernails, his DNA under her fingernails, the hair in her hands, the bruise on her forehead, fresh bruise on her forehead, the fresh bruise on her back, the items that are disheveled downstairs in this apartment. If Your Honor looks at the photographs, it is neat as a pin except for these items that are disheveled. The blinds that are torn down, the 3 blinds torn down near the sliding glass door.
Was she found without clothes on?
She had a top on, but nothing on the bottom.
And there was what clothes were found downstairs?
Her flowery pajama shorts were downstairs underneath one of the blinds. I think it was entangled with her panties, and there may have been a sock there also.
So she would have had enough time to come home and undress and put on pajamas? Is that, I mean...
Right.
Because she was also fairly, according to Mr. Morris, fairly inebriated that evening.
She was intoxicated and had been throwing up, in fact, which, by the way, is inconsistent with the defendant's story that she had consensual sex after she got home in this short period of time. We do know that his DNA is in her vagina and her anus, and the jury did not find him guilty on the felony murder, so that's where we are with that. But
did you separately charge sexual battery?
It was a felony murder, I believe, by burglary or sexual battery.
There wasn't a separate finding.
No, ma'am.
The jury could have just decided it's more consistent with a premeditated murder. I mean, we don't know.
Stop there. I mean, they did not say we do not find. They just didn't check the box, the line next to felony murder. That's all. So we've got very probative crime scene evidence that the jury was entitled to weigh. Extremely probative. We've got his statement alone. I mean, even if we didn't have this crime scene, but these two actually mutually corroborate each other in terms of him being lucid at Shands. I mean, his story at Shands, when basically he didn't have time to concoct a story, for example, about the abortion receipt, which was in discovery later on from the state. He didn't have time to concoct a story. He basically lied again at the very beginning of his statement to Shands, and then the detective said, hey, we got a match on the shell casings. Your gun killed the victim. And that's when he finally confessed and basically admitted that he shot her in the bed. She rolled out of bed, and then he shot her again on the floor. And
but the rolling out again is not, as we look at the evidence, it's more of I'm trying to protect myself from being killed. I mean, that's what the jury could have.
Right, but of course the key thing in terms of premeditation, that moment that premeditation is required, we have more than a moment from the first shot, her rolling out of bed, turning partially around, kneeling on the floor, and him shooting her again. And of course we also have the struggle downstairs. By the way, she also apparently got up to the upstairs at some point, because that's where the McDonald's receipt is and where her cell phone is. So she had gotten upstairs with the McDonald's receipt and the McDonald's bag at some point.
What's the state's theory of when the sex between the two took place? I mean, was it downstairs or I'm having a hard time trying to figure out. They struggle downstairs, she comes upstairs and he follows her, or just what was going on here?
So, we don't have a jury finding. My theory is that he raped her downstairs, but I'm not entitled to that.
Is that how the state argued the case?
Yes, Your Honor. That basically they had a fight downstairs. He at some point rapes her. She runs upstairs, and the evidence is consistent with the struggle downstairs and running upstairs, and basically cowers underneath the comforter. And that we have 2 holes in the comforter. Apparently, it must have been folded over. And he fired. He can't see her head then, but he fires. And if you look at the photograph of where the bullet wound is, if her arm had been raised to raise the comforter up, it would have been close to her head. So he fires once, and then she rolls out of bed, dragging the comforter with her, so it ends up on the floor with her. And by the way, she also had hair in her hands, which we didn't have to get DNA off of too. But at some point there was a struggle, as indicated by the items that were in disarray downstairs, the DNA under her fingernails, the bloody substance under her fingernails, the fresh bruises on her body. But where the rape occurred, or if there was a rape,
was the hair linked to the defendant? We
couldn't get DNA off of it, Your Honor. They tried to get DNA off of the hair. We know there was hair in her hand, but we couldn't get DNA.
Now, was it hair in her hands or hair under her fingernails?
No, the hair was in her hand, but his DNA was under her fingernails, and there was a bloody-looking substance that tested positive on a presumptive test for blood under her fingernails. And the bruises, these are fresh bruises to the front of her body, to the forehead, and to the back of her, onto her back. So they're fresh bruises in 2 different locations, and you tie that in with all the other evidence. The evidence of a struggle, the hair, the DNA, the blood under the fingernails. There is no doubt that a struggle occurred at some point before she was killed, and it was that night sometime. But, and of course, we also have as the court's already indicated, suggested, we have multiple statements by him. He's all over the map.
He never discussed a struggle in any of those statements, did he?
No, I don't think so. No, Your Honor. Basically, he first calls the mother the morning of January the 11th. This all occurred around 3:30 a.m. to early morning hours of January 11th. Later that morning, he calls the mother and said, "Well, where's Danielle?" And he calls her again later that day and asks, "I don't know where Danielle is." Pretends like, basically he's denying he was involved at all. And then he calls the police and said, I hear she's dead, and eventually talks to Detective Walcott and said, well, I left at about 3 a.m. or something, But he set the time for leaving when he knew that would take him out of the crime scene. And then, so that's another version of a story where he basically says, I wasn't even there. And then when it gets to Shands, he first denies being there again. That story is first consistent with what he told the detective over the phone in terms of his, by the way, his lucidness. That first part A of his story at Shands was consistent with what he told the detective over the phone. And then when confronted with the shell casings, that's when he finally admits that he knows that they got my gun And by the way, I had the same gun at the shootout with the police. That's when he finally admits to shooting her, and admits to her rolling out of bed. And then he changes his story again. He tells that this is in rebuttal, the state's rebuttal. He initiates contact with the police January 4th, 2010, about a year later. And his story then is, hey, I saw a light on in her apartment, and I went up there and she was already dead, and I wanted to get my gun, and so that I got my gun. So now he's trying to explain. He knows that he's got problems with the gun still. And so that's how I had my gun, because I went up there and got it. And then he changes the story then to, he tells that story to basically Dr. Corp the first time. This is getting into penalty phase evidence.
Well, let's go to, I think you've given
He's
us.
all over the map.
You've got a lot of, I think there's a lot of evidence that supports the state's case here. On the two other issues that were raised is the giving felony probation great weight, and then proportionality.
Yes, ma'am.
The state, as I see, had first asked for, was pursuing CCP, HAC in the course of a sexual battery, and they abandoned all those. So the two undisputed aggravators here is that he has felony probation and then the conviction for the felony. It seems to me that it's that other felony that occurs 2 days later that puts this into a whole other realm.
The prior violent felony.
Would you agree with that as far as how we look at this?
This is very similar to Phillips in that regard.
Because if we just had, and I guess we didn't have that subsequent thing, and we had this murder, and he was on felony probation. The felony probation he was on was, he was a first offender, I guess. So they're concerned, and my question is, the giving of that great weight. We've never said felony probation, depending what it is. If you're on for having had another murder, but that's not among the weightiest of aggravators, is it, this felony probation here?
It's not one of the ones this court has listed as among
we've almost listed everything. But how does a judge, in terms of, I know we don't question it, but why is that entitled to great weight? And how do we, what facts did the judge have, if we were just reweighing this to look at proportionality, that would say, when you have that kind of felony probation, which was, he was in I guess he went through a neighborhood at 120 miles an hour, that's in a death penalty case, that's going to be considered great weight.
Endangering children as in the chase at 120 miles per hour, narrowly missing a child, racing at 120 miles per hour.
But you sort of, again, we don't really need to reach whether that was erroneous weight, because isn't really the other aggravator so substantial here?
I would think, yes, ma'am. If there was error, which the state, of course, does not concede, it was certainly harmless given the extreme weight of the prior violent felony in this case, shooting at the police when they tried to apprehend him.
And what were the mitigators here?
In terms of what's not mitigation, Your Honor, you don't have any mental illness, you don't have any child abuse, no sexual abuse. You have an IQ score of 76 on the one hand. On the other hand, he graduated from high school, and he passed Halliburton's test to become a private contractor to work for Halliburton overseas. He traveled overseas as well.
So there was no attempt, because I know there's, just from reading in the newspaper, that those contractors can sometimes be subject to a lot of stress in that situation. There was nothing to tie in what had happened to him being in
I think
Iraq.
At one time somebody testified that he was shot at, but there was no testimony that I recall that had any effect on him.
So there was nothing like that he
psychologically.
went to Iraq, he was in this situation, and he came back a different person?
No, ma'am. I didn't see anything like that. In terms of what mitigators were found, the no significant criminal history, prior criminal history, that was given little weight, and that's basically issue 2. And the state submits that what the trial court did in terms of those the aggravator, great weight, and the prior criminal history, little weight, did exactly what he's supposed to do. He looked at all the underlying facts regarding the aggravator and regarding the mitigator. He said, well, he got to withhold on the mitigator, so I'm going to give it to him, but I'm only going to give it a little weight. On the other hand, we've got these serious facts underlying the felony probation in terms of the high-speed chase, endangering children, narrowly missing a child. By the way, there are even more aggravating facts than that to it. But in any event, we've got these serious facts underlying the felony probation, so I'm going to give that one great weight. And as Your Honor, of course, has indicated, the prior violent felony is extremely, extremely serious in this particular case. No other statutory mitigators at all. No mental mitigation, statutory mental mitigation. Religious faith, slight weight. Love for family, little weight. Employment history, little weight. His biological mother rejected him, slight weight. On the other hand, there was testimony that his stepmother and dad were excellent parents. I mean, he was raised by excellent parents. And, of course, we have this other evidence that he had an excellent family life otherwise. Emotional distress, he basically, Dr. Kropp did not testify as to the statutory mental mitigation, but basically Dr. Kropp bought the defendant's story that he was under some sort of emotional distress when he fired the shot, so the trial court gave that some weight. Essentially, there was also some testimony from Dr. Kropp. I should mention that there was mild to moderate frontal lobe.
How old was he?
He was 24 at the time of the murder. But Dr. Kropp couldn't say when that occurred. It could have occurred when he was shot up by the police. And there were a couple of accidents that the defendant related earlier in his life. There was a motorcycle accident, but the CAT scan was negative. For that particular incident, there was supposedly some football injury, but he didn't even go to the hospital for the football injury. So basically, you have very, very substantial, greatly weighted aggravation and very, very little mitigation in this particular case. So the state would contend that the trial court's determination of the defendant for death should be upheld, that the death sentence was proportionate. But if there are no other questions, the state would respectfully submit that the trial court should be affirmed, the first-degree murder conviction should be affirmed, and the death sentence should be affirmed. Thank you.
Just briefly, Your Honor, I have to take issue with this notion of a struggle and the items in disarray. The apartment was neat. There was an iron on the floor. She just moved into the apartment 2 days before. That was the only thing in disarray, or other than these 3 slats. And I don't understand how you get from these 3 slats that are lying neatly, one beside the sofa right in front of the back door, one draped over the sofa, and another one in front of the stairs. They're not torn up. They're not mashed. I don't know how you get this struggle.
So you would disagree with the trial court's findings?
I do disagree with...
What about the finding, though? Let's just take the struggle aside. How about the finding that she shot on the bed on one side in the arm, and that she doesn't fall off the bed. She actually rolls off, has a comforter, and she's cowering when the shot to the head occurs. Is that not based on physical evidence?
I think it's clear that the first shot, she was on the bed in the arm, and that she rolled off or moved off, and then the second shot was fired as she was rolling off or as she was on the floor. I don't think there's any evidence that he moved towards her to fire the shot. There was no expert testimony of any kind to show the position she was in, where he had to be when that shot was fired. Nothing.
When she was found
yes.
by the police, what position was her body in?
She was on the floor beside the bed. She was leaning over, sort of like this. Of course, the family was all in the room as well, all 3 family members. The mother testified she laid down on the floor beside her daughter and rubbed her. So we don't even know if the position she was found in was the way she was after she was killed. So
well, that's not, because the mother testified. They testified. The only thing the brother saw her and put a hole through the.
Yes.
Upset. The mother said she simply rubbed her back, but
she went
there's
in
no
there.
evidence that they moved her.
She laid down beside her. So I don't know what they could have moved. No one asked them. And then the bruises, again, she has 2 small bruises. The medical examiner said were consistent with falling off the bed. It doesn't make any sense. There's some struggle downstairs, and then somehow she managed to walk upstairs, and then it doesn't make any sense. So I can't buy that.
Was there clothing found?
Excuse me?
Was there clothing found downstairs?
Yes.
Part of her personal clothing? And,
yes.
And what does that suggest?
It was consistent with them having sex downstairs, which is what his testimony was, and then they went upstairs. And just going back to, I'd like to just, in my 16 seconds I have left.
Well, no, you actually
Am I
into
over?
Overtime, so don't get confused by thinking that the increasing number here means you get more and more time. It means you're more and more overtime, okay? But I'll give you an additional minute.
1 minute. Okay, proportionality. I cited cases in my brief that I think are consistent with this case not being a death case. I filed 2 other cases, Chakey and Jorgensen, yesterday. Now, Chakey killed his wife. He planned to kill her. He even tried to hire someone to kill her. He had a prior violent felony of a second-degree murder, which is similar to what we have here, and the court reduced his sentence to life. And Jorgensen was a meth dealer and meth addict. He had a prior second-degree murder. So I think if this court decides it's a death case, what you're saying is because of that fleeing and eluding, this tips the scale towards death. And I don't think that's consistent with the court's opinions for a man who has a borderline intellectual functioning, who was mentally and emotionally disturbed at the time of murder, and has no prior violent history, no significant criminal history. I think for those reasons, the court should reduce the sentence to life. Thank you, Your Honor.
We thank you both for your arguments. Now we'll move to the second case on the docket, Hernandez Alberto versus the state of Florida.
May it please the Court. I'm Mark Gruber with CCRC, representing Mr. Pedro Hernandez Alberto. And with me at council table here is Steve Malone on behalf of the United Mexican States, Amicus Council. The case, of course, at this point is fairly limited because of the posture that it's in, but I thought I might start with what was really my last stand at the lower court, which is if our arguments about competency were eventually lost, if my arguments that a verification requirement should be treated very liberally, and if the case is really headed to where it did wind up going to a dismissal with prejudice, that the court should then conduct a DeRocher hearing that would require a colloquy, and in this case most likely what amounts to a confrontation between the court and the defendant, to establish on the record that he actually knows what he's doing.
Well, Mr. Gruber, here's my problem is, and I'm sympathetic to what you had to go through with if you were his attorney, and the judges that tried to me mightily to help do something so that a post-conviction motion could be filed. But if a defendant is found to be competent, but is still saying, I don't want to sign that verification, and they're told that if they don't do that, they are giving up their rights to post-conviction. Are you saying that they really needed to go through a DeRocha procedure for this? That this was the same thing as if he was waiving post-conviction? Is that your argument?
My broad position would be that, frankly, yes, because it really wouldn't. I mean, it would take a matter of minutes, and that the idea behind the DeRocha hearing is to establish on the record, and of course, there's
so what would be the colloquy that wasn't done that if we were to decide, or if it's okay, well, we should relinquish and just let 5, sentences be pronounced, what would it be?
Well, I actually never did write a proposed one out, and if there were a relinquishment, I would do that and put some time into it. But it would be, of course, along the lines.
I guess my problem is this seems like somebody that is just gaming the system. And at some point, he is given, Judge Black, all the judges that tried to tell, to go over it, and then there was competency hearings and competency and experts, and there is just, seems that every effort was made to try to accommodate this defendant.
So I'm I am really hoping to persuade the whole court that this is not that type of situation, that there has been competence.
Let me ask you this. Let's assume that it were sent back, and the individual responds just as he had before and gave reasons. He gave reasons, did he not, for not signing it?
Well, he did not until towards the end, but eventually he did complain about what had been written.
Well, did he or did he not?
All right, yes.
He did?
At the end, he said he disagreed.
He disagreed with it, and that it disrespected him and his family. Those reasons. Did he not give those reasons?
I'm sorry, I didn't. That
it disrespected both he and his family?
Yes.
Didn't he say those reasons? Okay. I don't understand why we're having such a difficulty communicating on this. Did he give reasons in this proceeding as to why he didn't sign it?
Yes.
Okay. Now let's assume that we do send it back, and he gives those reasons again.
Well, then...
Because the court can't force him, we can't force him to say magic words. Correct?
Well, that's true.
And so we go through this, and we send it back, and those are the responses. Where are we, if that's given?
Well, in a situation like that, I would certainly try to get a discussion going on the record about what it is he disagrees with. And the very next thing within a matter of days would be a modified 3851 that meets those problems that he has.
Hey,
it wouldn't take much.
Minute. A modified 3.851 that has what in it?
That whatever it is that he doesn't agree with, I'll take it out. I mean, it will meet any problem that he might have with regard to the facts. There would still...
You can, as an officer of the court, if he wants to assert something that there is no basis in the evidence to assert, here is a defendant who represented himself for a good deal of the trial, and that was upheld. So there's really very little, in my view, that he could attack even if he was fully cooperative, because we've already upheld that he was, allowed to represent himself, and so therefore you can't fault counsel for his insistence on representing himself.
But I really want to resist getting into the merits of the 3851 that hasn't even made it to a Huff hearing yet.
Except, I guess what it does is we look at a whole picture. And, I'm always... So I think from my point of view, in trying to see what has a defendant done to not only not help himself, but to, is he doing it because he can't help it? Or is he doing it because this is just now, this 3.851, his sentence was affirmed in 2004, so we're 8 years later, and we still don't have the first 3.851. And there's a lot of evidence in this record that this defendant is gaming the system. So I say, look at the whole I do think to look at the whole thing. But I understand what you're saying is we can't say, well, just because there's nothing to file doesn't mean he doesn't have his day in court. But Justice Lewis is asking you, well, what if he says, I don't agree with this, but then doesn't tell you what he wants to have in it, or what he wants to have in it isn't ethically something you can put in it?
Well, as far as anything positive, affirmative, that he would say that I could not agree with, then I deal with that if it comes up. But I'm simply saying what he said is that there are certain things in there that he regards as offenses to his family.
You're supposing that you're going to have a full discussion and this is going to be just beautiful. It hasn't occurred up to this point after this number of years. Again, I go back to the basic question. If those answers stand, where are we?
Well, okay. One thing is that there has been an issue, when it talks about the phrase gaming of the system, there has been an issue here about his mental illness all along from the very beginning of this case. He was found to be incompetent at different times. There's an unopposed finding by the judge that he is incompetent for purposes of self-representation under Indiana v. Edwards. Our mental health expert said unequivocally that he is schizophrenic, paranoid, psychotic, and incompetent under the basic Dusky standard. So and Dr. Taylor, who was the court's expert, talked about both as being a possibility. He tilted towards competency to proceed, but then said he could not render an opinion with a reasonable degree of medical probability. So the mental health issues here have been going on all along. Now, I've said that if you get a defendant who difficult clients are routine.
I understand those. Do you have an answer for where we are? Okay, he's given these, and he's got these issues that you've explained. Mm-hmm. So then, where are we at the end of that day?
At the end, okay, if I understand what I'm looking for is a modified DeRocher hearing that would say if this is it, and you're rejecting the post-conviction third version that has been filed by CCRC, and you have some rational reasons for not liking that, then I'm offering to amend it.
Again, I mean, you're supposing it's going to have this wonderful colloquy and it's just going to flow. Again, I go back to the basic question, and it's not a trick question, and it's not necessarily an adverse question.
Okay.
Is where are we? If that answer is again given.
Well, okay, one of the arguments that I have here is that if he says, as he said a number of times on the record, that he wants to fight the judgment and sentence, that should be accepted under the particular circumstances of this case with recognition of the mental health history here. That should be accepted as if it were a verification.
Okay, so we should then go ahead with a post-conviction proceeding.
Yes, sir.
Without a signed pleading. That's where we are.
Yes, sir.
Right. And then the case and we don't have a rule that addresses that.
No.
Because it has to be signed. So what you're saying is that the circumstances carve out some kind of an exception that needs to be applied so that we have full justice in the case. That's sort of what you're saying now.
Yes, sir.
Okay.
And so
it's easy enough.
Okay.
And then what happens? Let me ask you this. If we accept your recommendation, as it were, to have this modified DeRocher and allow you to file a 3.851 motion that does not have the issues that he's contesting, yet at some point it's determined that these really are the best issues that he has to present, where does that leave us? Do we now, some years down the road, have to give him another opportunity to file a motion that has really maybe some meritorious issues? You know, I understand you're thinking about this, but it just seems to me that we then get into a real piecemeal situation of allowing you to raise these issues now, and then where are we going to be in the future, especially if the death warrant is signed. We're going to be running around trying to figure out these other issues that could have been brought, but he didn't want those brought at that time.
Well, partly just because you asked the question, what I would envision doing is litigating those issues one way or the other. But, I'm really speculating here about how I might cope with it under those circumstances.
Well, wouldn't the answer really be that if we were to have this modified procedure for something where it's close enough to that he's waiving, he's done something that he won't be able to change. In other words, this dismissal is it. Mm-hmm. When a death warrant is signed, you can try something else, but he's waived whatever he would have in the initial. And it seems to me that the colloquy would be, whatever you now file, this is your opportunity. And because, we have defendants that keep on filing, not a lot, thankfully, that keep on filing things where they're attacking their guilt. So say this defendant says, I want to attack my guilt. Well, he's confessed, there's no basis to attack the guilt. So that's why I know you don't want to get into the merits of it, but it doesn't seem that there's a whole lot he can attack to begin with. Maybe that's his problem, is that hasn't yet faced the reality that he committed how many victims?
Well, there were 2 murder victims.
2 murder victims. Yeah. So that's your best. That would be your best. That's your best argument. And I think the court. I would be concerned that we are just opening the door to allowing somebody to manipulate the post-conviction process. Well, and it's, you say people have found him to be not competent, but I thought that the DOC guards that have observed him say that when he's in prison, he's been very polite. He talks to people in appropriate ways. He's not disheveled. There's nothing that indicates that he is, mentally ill when he's going about what he's doing on his day-to-day death.
I have to say, all of the things that you're saying come from Dr. Annis, and we've got counter facts that have been established on the record over and over again.
But how many times has there been a judicial determination of competence to proceed?
I didn't count them all out, but it's been incompetent and then competent, and then under Indiana v. Edwards, partially incompetent.
Indiana versus Edwards, when Judge Black did that, it wasn't partially incompetent. It's the idea that we look to, and I'm not even sure if Indiana versus Edwards would apply in a post-conviction setting. I think there are other reasons we want to have attorneys for these defendants, because we don't want the death warrant to be signed and nobody be there. But Judge Black made a determination that he was not in a mental state that he could prosecute the 3.851 by himself. That's different than competency for the purposes of being able to stand trial or be subjected to death warrant or anything else. Would you agree with that?
Yeah, 2 things I did want to get in there. One, the sort of limited thing that I'm proposing might very well be by way of an unpublished order saying it would benefit the court to conduct a DeRocher hearing, and so as far as opening the door, it wouldn't do anything of the sort. But the other thing, that episode where we were reappointed by, according to Indiana v. Edwards, occurred after, it may be instructive, it occurred after the judge had conducted a Feretta hearing, relieved us from representation, and then Mr. Hernandez comes back into court with a copy of the Constitution, apparently, and demanded that his trial be a public trial, and had done nothing. And the judge then conducted a lengthy colloquy at the time. And
you saw him starting to act and say things that were inappropriate for what was going on.
Mm-hmm. He's done that over and over again.
What is the purpose of the verification of this particular motion and not other motions?
About that,
why do we require it in this particular motion?
In this particular motion, I have no idea. I don't think it does serve a purpose, and in fact, I've argued that it's a meaningless ritual. Now, the case law goes back a very, very long ways, requiring a verification, and the reasons for it apply to non-capital pro se prisoner petitions, a barrage of really frivolous petitions sometimes where the court then has the power to deny game time, or the prisoner may be charged with perjury. That obviously doesn't have much impact on a capital case at all. And in this particular case, the only purpose that would be served by a verification in any death sentence capital case would be to get the lawyer and the defendant together, and we've been kind of struggling around that, of course, for quite some time. But beyond that, I don't see where verification is required in a capital case.
It seems like that. I mean, having had a lot of experience as a trial judge in this area, it seems to me like this is the kind of thing that someone facing the death penalty can use to basically prolong his life as long as he possibly can. I'm just not going to verify that. Well, so you can't hear it.
Yeah, and the judge cited exactly that reason for denying my request for a DeRocher hearing. I don't think it's true. I think one way the case can move forward by addressing the individual claims, or the case can move forward at least by having it on the record that there's a confrontation, and here the defendant's actually being told by the court that this is going to be the consequence of what you do. The judge just wouldn't do that.
So the judges render basically two choices. One, dismiss it with prejudice, or two, do as you're saying. Go through the hearing and pretend like he signed it.
And it could be that the judge, after conducting such a hearing, says, this is it. The defendant has now been told he's sticking with his course of conduct, and the case is dismissed with prejudice, but we're not there yet.
You want an opportunity for the defendant to have a procedure under 3.851I, right?
Yes.
Okay. But didn't the trial judge give the defendant that opportunity to file a motion under that?
Yes.
And no motion was filed?
Right. That's when we were reappointed. I'll reserve.
I will give you an additional minute beyond the 36 seconds you have.
Good morning, Your Honors. May it please this honorable court. My name is Catherine Blanco with the Attorney General's office. One point I wanted to address first came on the last question of Justice Labarga, having to do with the verification and Mr. Gruber's representation, or his belief that it was a meaningless ritual. It is certainly not a meaningless ritual. It is a requirement under Florida law, long-standing, and as this court has seen with the claims that have been raised in Martinez out of the United States Supreme Court, allegations that the defendant was unaware of what his trial counsel or what his post-conviction counsel was raising or waiving claims. So it is a very significant requirement, and it is one that was repeatedly made clear to Mr. Hernandez. I call him Mr. Hernandez Alberto, but I believe Mr. Gruber calls him just Mr. Hernandez. So in any event, I'll do the same, Mr. Hernandez, by the trial courts in post-conviction in this case.
So the purpose for the rule is what again?
The purpose for the oath requirement, certainly there is an aspect of it that has to do with the under penalty of perjury. Now, as a practical matter, someone that's serving a life sentence or a death penalty defendant, certainly you say, well, okay, if we're going to prosecute them for perjury, how significant can that be? But the greater import of that rule is the defendant's acknowledgement. He is signing and verified. He knows what claims are being raised, because we're defending these years later, as this court has just recently seen, on claims that, well, I didn't know that was being raised, or my counsel did not raise what I wanted him to raise. So it's certainly a very important requirement under Florida Rules of Criminal Procedure 3.850 and 3.851.
Let me tell you, this is my real serious problem with this kind of case, and with a dismissal of this case with prejudice. This defendant has been around how long?
Well, the murders were committed in 1999. The trial was held in 2001. The post-conviction proceedings, a direct appeal was affirmed. He got an extension of time to file a cert petition, did not. Initial post-conviction motion filed with a Carter motion for competency determination was 2006.
We've dismissed with prejudice his 3.851 motion, correct?
Correct, Your Honor.
So now he gets to go to federal court without those issues that could have been raised in a 3.851 motion. He gets to go to federal court, assuming there are some issues, without those issues, correct?
Assuming that he's timely and assuming that he certainly can file any pleading. Now, whether it would be a viable pleading in federal court, and that's up to the federal courts to determine whether it's timely, whether there are claims that are cognizable, whether there are claims that are procedurally barred. This particular defendant, by his affirmative conduct, has waived.
Okay, so I just want to get to where we are, what's going to happen to this case. All right, he goes to federal court and may or may not get any kind of relief in federal court. Let's assume he doesn't, and then this case becomes ripe for a warrant. What are we going to do about these issues that now are going to be raised at the last minute? That we never actually dealt with on the merits. What are we going to do with that?
If it has to do with issues that were cognizable in post-conviction, Your Honor, this court's finding that the trial court correctly dismissed this case with prejudice based on the defendant's affirmative conduct, his affirmative conduct constituting a waiver of those claims, this court would only be dealing with any claims that would, let's say, be newly discovered evidence that would be properly raised or that could come under some exception, a new rule of constitutional law retroactively applied. So I cannot foresee what this particular defendant is going to raise.
Let me just go back to the question, though, about and I appreciate what you said about the importance of the oath requirement, especially in light of Martinez and some other things. I think it's an important one. But if the defendant is appearing before a judge, and essentially there is that it said either Mr. Hernandez, you either agree to this motion being filed with whatever you want out of there, or you are forever, there is no further post-conviction relief for you on these claims. And affirmatively gets him to state this under oath, because he's sworn before the judge, we really have almost a better than the verification, which isn't ever done in front of a judge. So, and I appreciate, let me say again, I appreciate what the state has had to deal with, what the trial judges have had to deal with, what Mr. Gruber and CCRC has had to deal with. But we know, and we get these cases, it's 1999, when we get this case in 2 or 3 or 4 years, or the federal court comes up with something, that the question is whether this case is tied together in a way that it is fair, it's just, and does it need one further colloquy to ensure that it is now laid to rest so we don't have these issues later. I realize the state goes, no, the judges did enough, and I understand, and I don't fault any judges, but that's my concern, is whether we're better off having one last hearing to have that done. And we've, again, DeRocha, all these cases have presented issues for this court. These are all difficult situations. So is the state at all say, no, that would be bad precedent, no, we can't do that? For this situation, wouldn't that perhaps be the best way to finalize the end of this post-conviction representation or this first post-conviction case?
Justice Pariente, you're right. The state's position is the trial court went above and beyond the call of duty and did enough. But I also understand that this court, if it has a level of competence that it would like to be higher, certainly can relinquish jurisdiction for, let's say, a 90-day period, 30 days to bring Mr. Hernandez back to the trial court, 30 days to work with Mr. Gruber. Mr. Gruber's represented this morning that, well, you know, I could strike some of those claims or change some of those claims. I could work with him.
Are you suggesting that we do that?
Well, he was given that opportunity in the articulation of the claims that or the objection that Mr. Hernandez had was made in July of 2010. In August of 2010 is when the order dismissing the case without prejudice.
Well, okay, you were responding to a question.
Yeah, sorry.
You've lapsed into history.
Okay.
Okay. The question is, does the state have a problem with us relinquishing this case for further proceedings to give them another chance?
Do I have a problem with it? No, Your Honor. Candidly, no. I don't think it's necessary, but I certainly respect this court's
why are we
decision.
Here?
Why are we here exactly? Why are we here if the state thinks that this should go back for further proceedings?
Your Honor, with all due respect, I don't think it should go back. I think it is sufficient. Would I have a problem was the question, and I respect the court's authority to do.
I understand.
You know,
I mean, let's not. I'm not trying to play a semantic game here. You need to articulate the position of the Attorney General with respect to what should happen in this case.
This case should be affirmed. The trial court's dismissal with prejudice should be affirmed because the defendant was given multiple opportunities to verify his post-conviction motion. He was explicitly given the opportunity to represent himself in state court in post-conviction. He declined to file his own post-conviction motion. Even after that, CCR was put back on the case. The case was amended. He was given, again, a 60-day extension to file a verified motion for post-conviction relief. He did not do that. It was essentially signing a verification that he failed to do despite specific opportunities. So I would say the case should be affirmed with prejudice.
Here is the thing, and it maybe didn't intend to go this way, but when the judge found that there was enough issues about his mental status that he couldn't proceed without an attorney. And that's what he found. Was that in 2010 or 2009, when counsel was reappointed?
In January of 2009.
When we're making a judgment, when the judge who has observed the defendant, and who has heard from the experts that he can't really do this himself because of his mental state, it sort of then is saying, well, but he had all these opportunities, as if we're dealing with a completely rational actor. And so some of these, I've read the brief from the Mexican consulate about Dr. Annis, who basically took, they say 12 minutes and he's was not bilingual, to evaluate the competency. So we're not dealing with somebody that we can say without doubt is a rational, bright, focused person. We're dealing with somebody that has, at least from the trial judge's point of view, somebody that cannot navigate this system on his own. And so that is why, again, in terms of saying, well, he's been given all these chances, enough was observed to have felt that counsel needed to be reappointed under Indiana versus Edwards, right?
The Honor, let me clarify the sequence. In 2008, in October of 2008, is when the Ferretta inquiry was conducted, and Mr. Hernandez was allowed to represent himself pro se. In January of 2009 is when Judge Black reappointed CCR. The second competency hearing was held in June of 2010. In that October 2008 hearing, where Judge Black is inquiring of the defendant and informing him again of the need to sign a verification, He advises him in Record Volume 32, and this is when he's requesting to represent himself. If you want to represent yourself and you want to move forward on this, you need to sign the verification. Do you understand what I'm saying? On page 283, the first thing that you need to do is you need to sign the verification so that you have a motion pending before this court. And then you can ask me what you want. You can file what you want and I will respond to it. But until you sign the verification pertaining to your motion, you don't even have a motion pending before the court that I can do anything about. I believe your lawyers have the verification here with them, and you need to sign it. Otherwise, we have no more business to discuss. At 285, well, okay. Well, you sign your motion so that I have a motion in front of me, and then we'll talk about discovery because the defendant was asking for discovery. Look, and then the trial court tells him at 286, look, if you don't want to sign the plea and use the motion that's prepared, that's okay. I'm just going to dismiss it, and then we're going to be done for today. And then you can file your own, and when I get it, I'll do what I need to do. And then at 287, I'm going to dismiss the one that lawyer prepared for you because it's unsigned and unverified and you don't want to sign it. That is now dismissed. You're now representing yourself and you're free to file your own motion. So, Your Honors, would I have a problem?
Was there anywhere in all of these proceedings, was there a discussion, and please, I don't mean to get into we're trying to talk you into something, but was there a point where the finality of all of this was presented to this individual that I hear what you just said, and it does say to lawyers, I'm dismissing it, you have nothing pending. I do understand that. But in more lay terms, that this is over, this is your last chance, this is the game, buddy. Is there anything anywhere in there that you can point to that makes that, clear or addresses that? Am I communicating with you, asking that this is it? Because that seems to say you can continue playing this game. That's what that seems to be saying.
That was the 2008 hearing. At the 2010 hearing, Your Honor, of July 29th, 2010, where you have the inquiry with Mr. Hernandez Alberto about why he won't sign, there is a discussion by the trial court that says, the question I have to ask you before we can decide what is going to happen with your cause is that there is a motion that needs to be signed by you under oath. I've placed you under oath. I don't know whether you have a copy of that. Do you understand the motion? And then they get into the dialogue about that.
Is that when was the Indiana versus Edwards determination made at that time? Had he already?
That had been made in 2009.
And
January
that's, I guess, what I said. So the in between when he's told he can file something himself in 2008, at the point when he comes back, he starts to talk about problems in the prison. And there's enough that goes on that Judge Black says, you cannot represent yourself. Although I'm not finding you incompetent, I'm finding you not, whether we call it not competent, to represent yourself in the post-conviction proceedings, correct? And now he has an attorney.
He's reappointed CCR in January of 2009, correct?
Okay,
and
so
then in June 2010 is when we have the second competency hearing, again with the two experts testifying. So we have the second competency hearing, and then on July 29th, 2010 is when we have this hearing.
Are you now back on Justice Lewis's question?
I'm sorry.
Are you now back on?
I'm sorry, yes, thank you, Justice Polston, okay. I am. I'm trying to get back to Justice Lewis's question with regard to what actually happened at the hearings.
I'm looking for words of finality, words that communicate, this is it. You understand what I'm saying? Not words of, okay, we'll go it again tomorrow?
No, not. Well, I'm just saying not in this colloquy. The judge tells him specifically, in order for us to proceed, I have to have a motion according to our law that's been signed by you. And there are two more references I'd like to briefly address to the court, but perhaps, and I hope this answers your question.
Where Justice August 17th, is that the one where that's the hearing where the first one was dismissed and gave him another opportunity? What did they actually say there? I think that might answer the question.
At the August 17th hearing, the defendant wasn't present. The defendant was present at the July 29th, 2010 hearing, and that's the colloquy that we've included, much of it, in our brief as well. That's the July 29th, 2010 hearing, and the defendant is present at this hearing. And Mr. Gruber, in the presence of the defendant and in front of the court, discusses, and the conversations I'm describing occurred at some length. This is Mr. Gruber speaking. There were substantial discussions, and they all involved the issues of what the claims were in the 3850, the substance of those claims, the procedural necessities, including filing requirements, including the requirement for verification. That's at 475. And at 485, in the presence of the defendant, the judge says, the state will file a motion to dismiss, and that's the best way to proceed at this point with the finding of competency. He's found competent. He's not going to sign. The rules require him to sign. And so that is the response that is given. Okay. Now, is there a sentence in there that says, and the court is the party telling the judge, dismissal with prejudice means that you cannot come back? There is not, Your Honor.
Thank you.
You're welcome, Your Honor. And indeed, the trial court did make several efforts to make sure that Mr. Hernandez understood that he was expected to sign. At the August 17th hearing, where the dismissal without prejudice is entered, Mr. Gruber agrees that it's up to them, I believe. Hold on one moment, Your Honor. Let me just get the correct passage. I'd have it, Tim. Excuse me.
As I understand, on August 17th, Judge Sexton said, I'm dismissing this case without prejudice. Right. I'm giving the defendant 60 days to send his own pleading in. And was there another 60-day extension? Is this the point where he had an additional 60-day extension from there?
There had been. At this one, there was only 160. On August 17th, Mr. Hernandez was not in the courtroom. Mr. Gruber was present. The trial court says, I have my order here. I'm dismissing without prejudice. And Mr. Gruber says, is in response to, I think the next procedural steps, she's talking about what happens next. And Mr. Gruber states, I agree, I think it's up to us. And there's a discussion of the ball being in their court. That order of August 17th states what the trial court will do. If a verified motion is not filed within 60 days, an order will be entered dismissing this case with prejudice. And so the defense is all unnoticed. They know that the ball is in their court. The time the clock ticks, nothing else happens. I would ask the court to affirm the trial court in this case in light of the multiple hearings and the multiple opportunities the defendant was given to verify. And the issue of competency, we would rely on the arguments presented in our brief. Thank you for allowing me to present an argument this morning in front of you. Thank you.
I'm going to thank the court for its attention. Unless there are any questions, I'll sit down. Thank you.
All right, we thank you both for your arguments, and the court will now stand in recess for 10 minutes.
All right.
We will now take up the case of the City of Palm Bay versus Wells Fargo Bank.
Good morning, Your Honors. May it please the Court, I'm Steve Brannick of Brannick and Humphreys, here representing the City of Palm Bay. We've got in front of us an important case concerning a city's exercise of its home rule powers. The specific question is whether a city like Palm Bay can adopt an ordinance that gives its code enforcement liens super priority. And we think the answer to that question is yes.
Is there any distinction? I know the League of Cities asked us to make that distinction between a lien that is for a fine or a penalty, like it was here at the $50 a day mark, and a lien for when the city comes in and actually repairs the property, and so there are repair costs. Did your statute address both types of, is it priority for both types of liens? They stem from the same ordinance in this case?
The statute does not distinguish
between
the two types of liens.
Is there any kind of a legal distinction that the League of Cities would have us make as to the super priority for a repair cost lien versus a fine or penalty lien?
All right. Our position is that there is no distinction, and that both for the purposes of the preemption analysis and the purposes of the due process analysis, under both circumstances, the ordinance survives both constitutional and statutory scrutiny. So we don't see that difference. I understand that different arguments can be made in the due process context, and the Florida League of Cities has forwarded those arguments. But our position is there is no difference because, number one, there is no preemption, and number two, the bank here contracted with notice of the super priority statute, and in fact incorporated within its own contract that it was going to be subject to ordinances such as that. So we don't see a problem.
How broad is this power? Does it cover the entire width of the world with regard to what could go into a code of a municipality or a home rule charter kind of organization? Is it that broad?
The basic law, there are two fundamental propositions that we rely on. One is that unless the Florida legislature steps in and says, city, you cannot regulate on this subject matter, the city has exactly the same powers as legislature.
As a legislature would.
That's the first proposition. Right. And the second proposition is if any matter that the legislature legislates on, the city has the power to legislate on as well. So
it is. I mean, it's basically as broad as the world then. I mean, you got some constitutional limitations, but this is huge as to what they could go on.
Exactly, with the legislature having the right to step in at any time and to exercise its right to preempt. But it hasn't in this case, and that's our.
But you do acknowledge, don't you, that the city cannot adopt an ordinance that is in conflict with a state statute.
Right.
Now, I guess I guess there are two issues here, and your brief has addressed them, as have everyone's. Whether the statute that creates the right to have a code enforcement board. Now, that's a state statute.
Yeah.
Why, if, I guess you're more of a preliminary question, why, if the municipalities are free to do whatever they want in this area, couldn't they have done that? Why do they need the state authorization for a code enforcement board?
Well, because of the Article 1, Section 18 of the Constitution, which says that the city cannot penalize someone except pursuant to law. So that constitutional limitation kicks in.
Okay, then there would be a distinction, though, for my scenario or the League of Cities, where it's for repair costs, it's not a fine or a penalty. Would they still need 162 for that? If they go in and they have an ordinance that says that if you won't fix your property in 30 days, we will come in and repair it for you, and there will be a lien, and we will. Yeah.
I think there would be a good argument that a repair cost is not a penalty.
Okay.
But we're definitely talking about fines here.
Okay, so that's why 162 is important. Now, there's an argument. Is there an argument to be made that it's sort of what 162 doesn't say, that because it talks about liens, but it doesn't say the lien is to have a priority, that means that statute does not provide authority for a super priority lien? I mean, that's one of the arguments that's being made.
That's their argument, and our argument in response is that, first, you have to show a conflict. The statute gives the city a right to a lien, and the city has taken and imposed that lien. The statute then does not go ahead and impose any limitations on the sort of lien that may be granted. There's a whole separate body of law that tells us about lien priorities, and there is no indication here that the legislature, in adopting Chapter 162, has reached out to preempt essentially the separate law that applies to lien priorities. So there's no... in order to show preemption, they have to show that the legislature has affirmatively stepped in and said, city, you may not legislate on lien priority, and there's no such thing.
But I understand that's the way you want to frame the issue, but why isn't it more sensible to look at it this way? The legislature has established statutes that under which lien priorities are established. And it's a little complicated because we're a notice state, and but so you've got to look at the date or the time when something's recorded, but also actual notice and circumstances all related to that. So it's complicated. But that all flows out of a statutory scheme that the legislature has. There's a common law backdrop to it, but there's statutory provisions that reflect that. Is that all correct?
That's correct.
Okay. Well, but what you say is that scheme is there, and under that scheme that the legislature has established, Wells Fargo wins. But the city can come in and say, no, Wells Fargo doesn't win. We win because of our ordinance. I don't understand how that ordinance, which displaces the priority that is established under the statutory scheme, can be viewed as anything other than being in conflict with that statutory scheme.
Only if you look at the statutory scheme very narrowly and you focus solely on 695.11, which is the first in line, first in time, first in right statute. But that's only a very small part of lien priority.
You look at the rest of it, too. You look at the part about the first section there in that chapter. Right. You look at the other provisions in the statute that give super priority to some other things. You look at all of that.
Right.
And what you're doing something, the city is attempting to doing something that does not fit within that. It displaces the priority that would be established by that scheme, and with another priority that's established by the city code, right?
But I think what Your Honor has I think acknowledged is that this is a complex scheme with lots of statutes, lots of common law that you have to look to. What they have to show to find preemption is that the Florida legislature...
Let me ask you this. We talk about common law. Can the, and I don't know how this plays into all this here, but do the home rule powers of the municipalities allow them to displace a common law rule?
I would think so, yes. I mean, I hadn't really thought about that, but I don't see any reason why not.
Let me just make sure. We went from 162 to 695. 162 clearly doesn't, which is, I think it's 162.
Right, that's correct.
It actually doesn't, as I'm looking at it, it doesn't even talk about a lien being imposed, right?
Well, it says that they may impose a lien, but doesn't say anything about the priority of that.
Right, okay, that was my first question, right. Is whether by not saying anything about it, did the legislature intend that there not be priority? That's one argument that's being made by the respondent, correct?
Right. Exactly.
Okay, now the second argument, though, has to do with 695, right. Which is the first in time. It's actually entitled Instruments Deemed to be Recorded from the Date of the Filing, which, seems like it's a default rule, but it's an important one.
Right.
But there's no question, and this is what I'm sort of struggling with, there's no question that the legislature can come in, as they have for condominium assessments, for all sorts of things, and supersede this without
they can
even
impose any limitations
without referencing 695. Do they have to reference that this supersedes 695?
They haven't. I mean, there are all sorts of super priority exceptions, and none of them reference 695.
They don't reference, go back to...
right.
Okay, so your point, and this is that the legislature is giving through the Constitution plus the statute gives the municipality the same right to do what the state is doing.
Exactly. And so maybe the simple answer to your question and Justice Kennedy's question is that we all know that the legislature can adopt statutes that affect super priority. The code's loaded with them. And the simple proposition that we're pointing out is that the cities have exactly the same power that the legislature does. So the city has the power.
But they don't have the power to adopt a priority a super priority that conflicts with the priority that's been established by the legislature. I just don't see how those can be reconciled.
If the legislature had a scheme that said first in time, first in right, always, and we reserve to ourselves, the legislature, the right to make exceptions, I think that would be a point well taken. But that's not what the statute says here.
Well, you're saying they've got to expressly preempt. There's got to be an express preemption. You can't really have a conflict.
No, I'm not saying that. Number one, we all know there's no express preemption because 695 says nothing about express preemption. So the question is there a conflict? And our point is, how can there be a conflict when you have a scheme that is full of exceptions?
Well, let me ask you this. When the city filed its lien, how did it file its lien? Did it have to be done in the official
records?
So on the lien itself, there was a sign, just like here on the final summary judgment. There's going to be an OR book number with a page number, right? And that number is going to be higher than what Wells Fargo lien was.
Right.
So why isn't then under 695.11 that controls the priority, and to the extent you argue otherwise, there's a conflict?
If 695.11 was the end of the analysis, I would agree, but it's only the first step in the analysis. You have to look at 695.11, then you have to look at 695.01, which is the notice statute, then you have to look at the common law relating to when someone has actual or constructive notice, and then you have to look to this whole panoply of exceptions that the Florida legislature has put into the statute.
Effect. The lien did not exist until after Wells Fargo lien. Right?
That's true.
So but don't you have to look at this? It just seems to me that when you look at 695, and if you go by strictly what they say in 695 about the recording, okay, and the priority and recording, and you look at what the state did, I guess it's the municipality did here, I don't understand, I guess I'm saying the same thing that you said, how that doesn't conflict with 695. What the municipality did, they actually are saying, no, despite the fact that my recorded number is higher than that of this other lien holder, I'm going to jump in priority.
In determining whether there is a conflict, you don't look narrowly at one piece of the puzzle. The Sarasota Alliance case, which Your Honors decided in 2010, said that you have to look at the entire statute and its object and purpose before you determine whether there's a conflict.
But the whole statute was passed by the legislature, so we are all clear that the legislature has that authority to, in fact, make exceptions to the broad 11, correct? The legislature
has that authority.
Okay.
And our point is, and it's a very simple one, if the legislature has that authority, then the city has that authority unless the legislature steps in and says no.
You're saying if the legislature passes a law that has some exceptions in it, then the home rule power of municipalities allows them to add exceptions.
Let me give you a perfect example.
That's what you're saying?
No.
You did say that. I think I heard you say that.
All right.
That's not what you meant to say.
No. Let me give you an example of two different statutes to show you the point I'm trying to make. If we go to the Public Records Act statute, and this was the Tribune Company versus Canella case, which was an instance of field preemption, the statute says public records shall at all times be open for inspection by all persons. And then, of course, the legislature has some exceptions. Now, Your Honors determine that when you have a statute that says for all time and for all purposes, public records are going to be open, that preempts the ability of anyone else to come in and make an exception. So in the state of...
Even though that law has exceptions in it.
Exactly, because of the important proviso in the beginning of that statute that says public records are open for all times. We don't have that sort of proviso in Chapter 695, and that's the big distinction.
It's unequivocal about what it says about the priority and notice. Now, there are other things that have to be looked at to determine that there are some exceptions to that, but that language in that chapter seems to be unequivocal.
All that chapter says, all 695.1.1 says, is that in determining who recorded first, we look at the lower number. That's all it says. It doesn't say a thing about ultimately who under the law has priority. Now we have to go to 695.01, and we have to go to everything else. It's a very big bundle of statutes and common law principles, and our point is that since you get lots of different results under that big package of common law principles and statutory principles, you can't read into that, which is what they have to do, an intent from the legislature to prohibit anyone else from making an exception.
But it seems like to me you're saying if the legislature does something that's really complicated, then municipalities have the ability to come in and tinker with it.
Your Honors decided exactly that in the Sarasota Alliance case in 2010. One of the fundamental principles that you decided in that case was it doesn't matter whether you have a complex statutory scheme. What matters is whether you see an intention by the legislature to step in and stop cities and municipalities and counties from regulating. That's what you have to look at, not the complexity of the scheme, but whether you...
Well, that's a question about preemption as opposed to conflict, right?
Right.
That's the issue there. I'm not focused on preemption. I'm focused on conflict.
Right. And I'm saying if you have a system where you get 10 different results in 10 different cases, depending upon the parties, the notice, the statutes that apply, how can you read into that a blanket rule that first in time, first in line, always wins? If this had been like the Public Records Act and they had that sort of proviso that says first in time always wins unless the legislature makes an exception, then we would not be arguing that the city has the right to come in and make an exception.
Why doesn't the last sentence in that statute do that? An instrument bearing the lower number in the series of numbers shall have priority over any instrument bearing a higher number. Why doesn't that do exactly what you suggest?
That tells us who recorded first, but we all know that...
It also establishes a priority, right?
In some cases, but not all the cases. Not in any of the cases where the legislature has adopted a super priority statute. Not in any case where there's a bona fide purchaser for value without notice.
Well, there are exceptions provided by the legislature in other circumstances. None of those exemptions or exceptions exist here for your client.
But the point is, if the legislature has the power to make exceptions, then the city has the power to make exceptions, unless the legislature has stepped in and said cities and municipalities don't have the power to make exceptions.
Exceptions to the exceptions.
What are examples of some of the areas that, like condominium assessments, are something they've legislated? Right. I mean, it's not as if, and again, this is sort of because I do see your point. I don't know if I agree with it, but I see it. The legislature has made plenty of exceptions to give super priority to things that are probably less important than the municipality's ability to enforce its code and have liens for both penalties and costs. And that's so it doesn't conflict with anything the legislature is doing. If anything, the legislature has minimized this first in time by coming up with all these other exceptions. Correct?
Exactly.
But it seems to me that we get into a real conflict here with whether or not, when you say that the municipality can do the same thing that the legislature, what they're actually doing is overruling to some extent, in my mind, what the legislature has already set out. So I just don't know where this would end up taking us if they make a statute and the municipality can continue to make its own exceptions to that statute.
But doesn't the legislature... go ahead, answer your question.
I guess the basic point that I'm making is that municipalities have exactly the same power to legislate as the legislature does. And so you have to find either a clear expression of preemption or a clear expression of conflict. And all we're saying here is we all agree that there's no clear expression of preemption, so there has to be a clear expression of conflict. The perfect example of the clear expression of conflict would be the Public Records Act, which says records are open at all times for all purposes. That makes it clear no one can make an exception. The legislature has not, in Chapter 695, stepped in and said that no one can make... Pardon me?
The legislature can make an exception, and they do.
Yes.
And they have.
To the Public Records Act. But because of that important proviso in the beginning of that section, other folks, the cities and municipalities, cannot step in and make other exceptions because it conflicts with that proviso. And if we had that sort of language here that said for all intents and purposes, for all times, no exceptions, first in time applies,
Mr. Brannon, we have used all your...
Can I ask one
sure,
question?
absolutely.
It seems to me that in the area of forfeitures, we have both local forfeiture provisions and state. Is that a fair analysis?
That's
of
right.
the
In the city of Hollywood case, you allowed that to go forward.
And so then I'm trying to understand. So then if a municipality, home rule municipality, would say that when real estate is used or involved in connection with drug activity, then that is forfeited, and that forfeiture, if it's recorded, would take priority, could wipe out a mortgage then, if it is so provided in a code.
It could.
Okay, well,
again, if there's no, I'm not completely familiar with the forfeiture statute, so I don't know whether there would be a preemption argument there or not. But
we have exhausted all your time. I will nonetheless give you 2.5 minutes for rebuttal.
I appreciate that, Your Honor.
May it please the Court. My name is Matt Canigliaro. With me is Leah Sevi. We are with Carlton Fields, and we are here today on behalf of the respondent, Wells Fargo. The legislature has given cities super priority for tax liens, for special assessments, for certain water, sewer, and other type utility assessments. The city's position ultimately is that the legislature didn't need to adopt any of those statutes, because any city could simply use its home rule authority to adopt an ordinance like the one here that says this type of lien gets a super priority equal in dignity to tax liens.
Can I, just as far as the posture of this case, are we here just to decide the issue of whether for Wells Fargo has priority over the city of Palm Bay? Or, because there's been some, the question is, if we follow what you're saying, this statute's unconstitutional, right? But nobody has actually raised the unconstitutionality of the statute. So how, or have they, of the ordinance?
I think I'm confused by the question.
Well, in other words, there was some argument by the amici that we should only answer the question as it pertains to Wells Fargo and not the bigger question. Is there a way to do that?
They were the court's amici in opposing counsels, not really ours, but let me try to say what I think they were saying. They were trying to say, can we leave for another day the circumstance where the lien is based on recouping costs? And in this case, that's not at issue. I think I agree with opposing counsel that it's hard to do that here, that this is really one approach. It is one ordinance, and it says that these liens get a super priority. And our position is we agree with the 5th DCA that ordinance is invalid.
Invalid. Okay, so that's the invalid. I use constitute. I meant invalid.
I do want to at least suggest that in a different case, there might be different arguments that would be made by the city about where they might be able to argue that there's a different circumstance where you have liens that are based on recouping costs. That wasn't done here. We're just under the single ordinance that's in front of the court. And I don't want to suggest that those arguments will work or won't work. I just want to suggest that may be a different circumstance. And I think that's what the amici were trying to do.
Okay. Now, the other circumstance is that although no question your mortgage was filed before the lien, or we wouldn't be here, I assume, the mortgage did say the mortgage was entered into after the ordinance was enacted, and the mortgage does say subject to all applicable law, including local ordinances. And in fact, one of the arguments that Wells Fargo has is, hey, you should have told us about that you're going to be assessing our property owner, because we would have come in and told them you better pay it off. So is there, and again, as far as that we have to look at the facts of the case, the fact that you could have agreed with the city to let their lien have priority, but the fact that your mortgage says it's subject to all applicable law, which includes the code enforcement lien ordinance, what is the argument as to that contractually you have agreed to the priority?
I think our contract in this case gets us to the same place the common law would in the absence of that provision. The contract here, it does reference applicable law, but that's a defined term. And the definition of that term reads that applicable law means all controlling law. And our position is simply that if an ordinance is invalid, it's not controlling law. That we, in this contract, which is very similar to countless other contracts, the parties weren't adopting invalid laws if they're in fact invalid or if they're in law invalid.
So that's your argument. Now, on this issue of whether, do you agree there is no express preemption in this area? Or do you, or I don't want to, do you agree or disagree with that?
We disagree in several respects, but let me try to quickly paint the larger picture. We presented 4 different arguments to the 5th DCA. It ruled on one and didn't proceed to reach the other 3. The first is that there is a conflict with 695.11 because the last sentence of 695.11 states an instrument bearing the lower number in the then current series of numbers shall have priority over any instrument bearing a higher number. That language has been held to mean that that is a priority of interests. It's not only in this case, but in prior cases. And that is a conflict that cannot be reconciled. The state statute wins.
Well, here is, but the problem with that, because looking at this, yes, but it does say instruments deemed to be recorded from time of filing, which seems like it's, again, more of a, possibly a mechanical recording statute, is that then the legislature, as you said, has gone on in numerous examples, numerous statutes, to say, but this has priority, and that has the priority, and the condos have, assessments have priority. And so each of those statutes would be in conflict with this statute if it wasn't that this just sort of set a default subject to everything else. Now, it would be so easy if they said subject to any exceptions that are created by legislative acts, and so that you have that as a reference. But if we were here on a statutory construction between this statute and another statute that created a super priority, we'd be in another, you'd say, well, there's a conflict because this is an absolute statement, but it can't be an absolute statement.
Well, it's not an absolute statement, Your Honor. If we were here in that situation, I think my response would be you would apply the statutory construction principle that the specific governs over the general. And what you have here, by the 5th DCA's opinion and by other opinions that have said the same, is a general principle taken from the common law. The common law rule was first in time, first in right. And that's what the last sentence of 695.11 does. It creates that general default rule. And the legislature is perfectly empowered to create exceptions as it wishes.
Now, why, and with that, Mr. Brannick's argument is that then why isn't the municipality also, since they have the authority to create the lien, empowered to give it priority?
And I will use this answer to try to address 695 and 162 as well. The simple first answer is when the legislature sets a general rule in statute, it is the legislature's prerogative to create exceptions, but it is not a municipality's prerogative through its home rule powers to create exceptions, unless there's some authorization to do that. And here there's not.
But I guess the question is why? That's what he's saying. What's the policy reason? In other words, it's not what I said earlier is they've created all these exceptions. It's not like they very carefully go only tax liens will have exceptions. I mean, I don't know if there are, I'm not saying that condo assessments aren't important, but, again, we're talking about priority over a mortgage, which seems like that should be the first, but they have a lot of others that get priority. So how is it that the legislature's intended that if they're going to be creating numerous exceptions, that the municipality, for its own for the safety, health, and welfare of their community, because that's directly related to code enforcement, can't give that lien priority? I mean, it's a very important thing for the residents of the city to make sure their properties there are maintained in a safe and healthy way. So that's a good. So why wouldn't that be something the legislature would have said didn't need to say is fine because it's within their authority?
As I hope comes across from our brief and from the Land Title Association's amicus brief, property in Florida is extremely important, and how real property is handled across the state on a statewide basis is extremely important. I think one of the premises of the Land Title Association's amicus brief was just to encourage the court to be careful and not say anything that would make it sound like Florida is no longer a notice state, because we are a notice state, and of course we agree we're a notice state. But that's the significance and the importance of what's going on here on a state level. And when the legislature decides it's going to adopt a statute that creates this general rule, and if you look at the exceptions, they're very precise, they're very particular. And I could go into some of the details about the merits of each one.
Okay, so you're saying because land is so important. I guess my question is, we've got how many of these liens priority statutes in the state? A lot of municipalities have enacted them.
No one's given us a number, but we're assured it's a lot.
A lot. Nobody's they haven't been challenged until now, or maybe they haven't been challenged. The legislature, who is there to see all of this, I mean, it seems that where you're saying something's very important, yet this statute's been on the books since 1997. Lord,
yes, sir. Yes. And it has, but things have changed. And I'll suggest too, and this is sort of staying in the policy area, not so much the strict law of what governs this, but two things have changed. One, the equity that was common in folks' homes isn't as common right now. And so who has priority has become much, much more significant in many cases, whereas maybe it wasn't as important before. Second, municipalities are looking to find ways to generate revenue. And so fines and penalties, I mean, we're here over grass and a fence, and it resulted in $30,000 in penalties. That's what's going on right now across the state, that the cities are looking for ways to generate income. So these things are now...
On the home of a man who's overseas serving in the military.
Away in the military, Your Honor, yes. And...
Let me ask you this. It seems to me that your opponent's argument essentially is that we have the general statute 695.11, and maybe he can correct me if I'm wrong on his rebuttal, and the legislature has made exceptions to that statute, and that a municipality, a home rule municipality, can also make exceptions to that statute as long as their exception does not try to trump a legislative exception. I think that's essentially what is being said here. And so what's wrong with that argument?
That if the city creates a conflict with a statute that's set forth as a general rule or default position, I'm going to say general rule more clearly.
But the statute itself doesn't say you can't have any exceptions to it, right?
No, it doesn't. But it does say, I think with some clarity, that an instrument with a lower number shall have priority over an instrument with a higher number.
Well, the problem I have with that is 161 says that, and we are not giving anybody any power. The legislature has given the home rule municipality the power to enact any legislation which the legislature may have, except when it's expressly preempted to the state or the county government or the constitutional general law. And if the state can make these exceptions and they don't preclude the municipalities from making the exceptions in terms of the priorities, why can't the municipalities do what the statute said, referring to the Constitution, that the legislature could do?
Because this court has said in its preemption-type jurisprudence that if there is a conflict, then that's a form of...
Where's the conflict? The problem I have is the legislature knows how to say, well, they could put words in fact that no governing body other than the legislature shall, a simple line, and that would have precluded the state, the county or the municipalities from infringing on that. It has to be expressed. Where is it expressed in here?
The expression is in the statement, shall have priority. That's a...
I know, but then the state makes exceptions.
And that's the state's prerogative. The legislature can do that.
Well, now the municipalities have the same power the legislatures have to make exceptions. They didn't...
And on that point, we disagree, Your Honor.
Huh?
We disagree on that point, Your Honor, that they do not.
Okay.
And if I could add a few additional reasons why there's preemption here. We've been talking about 695.11, and we stand completely on the 5th District's opinion in that regard, and would suggest the court does not need to go any farther than the last sentence of 695.11, finding a conflict, deciding that the ordinance is invalid. But even beyond that, looking at 162, the chapter on code enforcement liens, there are multiple problems there. We have cited... discuss at some length the City of Tampa versus Braxton case in numerous Attorney General opinions that go back decades, explaining a couple very key core principles. First, that this act is presented to cities and counties on basically a take-it-or-leave-it basis. They have the power under this chapter to adopt or to abolish that act as provided herein. And what the second DCA and what the Attorney General have said for decades is that they don't have the power to change it. They don't have the power to create new remedies. They can't even adjust compensation for the board members of the local board. That this is presented by the state to the cities. As counsel said earlier, it's all in connection with Article 1, Section 18. There's a constitutional basis for wanting to do this. But it's presented on an as-is basis. If they want this, they take it. If they don't take it. Let the county court system process code violations. And that's a critical principle, because what's happened here is a critical change to what the legislature's done. As we heard discussed earlier, there is an extensive statute at 162.09 subsection 3 that discusses these liens, and it discusses them in depth, in detail.
Which statute?
162.09 subsection 3. And it discusses them in extraordinary detail, and who they can be against, when they come into play, what property they cover. And they cover not just real property, but the personal property of the owner. When you can foreclose, how it can be foreclosed, who can execute a satisfaction release. There's incredible detail right there on this very point, even beyond the fact you're supposed to take or leave the act as a whole. On the lien issue itself, there's extraordinary detail from the legislature. And what the city has done in this case is stepped in and said, we don't like the remedies because we can't collect enough money from them, so we're going to improve them. And they can't do that. And that's getting beyond 695.11 into this whole separate area. But I want to make sure the court is aware that we've presented these multiple arguments. We think each of them works, although the court never needs to reach the later ones.
Well, you've got an entirely separate argument about due process, which means even if you lost on these other arguments, because you won on the due process argument in the trial court, and that was not raised in the district court by the city as a basis for reversing the trial court, then they're jammed on that. Isn't that correct?
Yes, Your Honor.
What was the due process? And I'm glad we're going to just talk about due process. What was the argument made about the due process at the trial court level?
That it is a violation of the, in our case, the mortgage holder's due process rights to not be informed, to not receive notice, actual notice, of what's going on here.
In other words, that what you said, and it is, I think there is something about to look at the facts of this case, that if you've got a property that is causing a problem and you've got an absentee landlord, the mortgage holder gets notice, they can step in and fix it or pay the fine. So
if there's a super priority, yes, Your Honor. If the city has validly set up a system,
well, even so, it would seem that there'd be an interest in not having proper. You're still going to have to. If they default, doesn't the mortgage holder have an interest in property being maintained? That's similar to really what the city has, other than they're wanting to get all the money out of the fines.
Well, yes, Your Honor. And these fines, the city picks a number within the statutory range, and now these fines can run on a daily basis, and we weren't informed of them.
Now, here is, though, the problem is that goes to something else, so that was not, you won on that basis, and that was not appealed by the city?
Yes, Your Honor.
Was not?
Was not
appealed. So that issue is not before us at all. Well, then,
yes, Your Honor.
Doesn't this whole issue, isn't this issue moot as to you? I mean, if you've won on due process and there's no decision on it, I mean, you still, and you like, of course, you like the 5th District opinion, so that certainly wouldn't hurt you. But even if we reverse, you win. Yes?
The opinion that the 5th District issued reaches a very serious, very important issue. And the question that the court certified is a very serious, very important question.
Again, and that may be a separate issue, but you're agreeing you win no matter what, even if you lose here.
We certainly hope we do.
Yeah. I mean, well, but the question, and I think the policy of whether a mortgage holder should get notice is good, but if you've just gone through this sweeping statute that sets it out, that doesn't require that the city give notice of the fines to the mortgage holder, does it?
Because the statute doesn't have a super priority provision in it that would displace folks like us who otherwise would have priority, and that's the key problem.
So that's the only reason you'd care? You don't care if your property goes into disrepair? You just care if you don't get your mortgage back?
Well, I don't want to suggest that, Your Honor.
Okay.
You've exhausted your time, but I'll give you another minute.
Well, I'm going
to give an opposing counsel.
I appreciate that, Your Honor.
2.5 minutes.
Just to sum up, the 5th District correctly read 695.11 as being what counsel acknowledged here today, what other courts have held over the years, that it contains, that last sentence is a substantive provision affecting priority. And in that, because that provision is in conflict with this ordinance, which tries to create an exception to it, the ordinance fails. The statute prevails under these circumstances. If the court is to reach the 162 issues, we think there are multiple reasons why under 162, based on existing case law from the 2nd DCA, based on decades of Attorney General opinions that have guided this state along its way, that the city cannot change this act, cannot give itself a better remedy, and so the ordinance for those reasons is invalid as well. Thank you.
Can you address this due process issue? It sounds like the city, even if they win, they lose. Is that correct? You didn't appeal the due process finding of the trial court or raise it in the 5th District?
The due process argument was argued in the 5th District. It was not raised in the initial brief, but when the bank raised due process as another reason for affirmance, then we opposed that in the reply brief. So it was argued in the 5th District. It's been argued here, but we join with counsel in suggesting that no matter what happens to the due process issue, we think that the certified question needs to be answered.
Well, let me make sure I understand. The bank raised it because they said, well, regardless of this other issue that the city's raised, we still win. The trial court has decided on this other ground as well.
Right.
Then you think somehow that preserves the issue for our review?
Well, they didn't stop there. They didn't stop with a procedural argument. They went ahead then and made an argument on the merits of the due process argument, and we responded on the merits of the due process argument. So it was briefed and argued in front of the 5th District.
But you didn't raise it.
Argued here.
You did not raise it in your initial brief.
Not raised in the initial brief.
The argument and I don't know, I think it seems to be almost a better argument is the pervasiveness of 162, and especially the section that sets up the lien. It would seem to me that that would be the place that if the legislature wanted to give you the municipalities the authority to provide the lien super priority, they would have done it right there.
But that's precisely the point, Your Honor. We don't need to have the legislature's authority for that.
Well, do you not agree, though, that the whole with what Mr. Conigliari is saying, that the whole code enforcement scheme is not something that the municipality can pick, that they've got to accept it? They can't go to other remedies?
No, we completely disagree with that. The cities may regulate code enforcement liens so long as they don't do it in a way that conflicts with Chapter 162. The super priority lien does not conflict with Chapter 162 because Chapter 162 says nothing about the priority of the lien. All it says is that the city may impose a lien.
Was the lien required to be filed under 695.11?
Was it required to be filed?
Yes.
I mean, it's required to be filed under the code enforcement statute in order to gain any priority. Was it an instrument
that's required to be recorded under 695.11?
In order to receive priority under Chapter 162, yes, it has to be filed in 695.
So it was under the first part of 695.11, it would be considered an instrument required to be recorded.
Yes. But that doesn't resolve the question about whether there's a conflict because 695.11 is just one small piece of the puzzle. The point is we have to go back to the Constitution. The Constitution says that the city may exercise any power except as provided by law, which means that as we sit here today, what we have to look for is an intent by the legislature to step in and state in its statutory scheme that the city does not have this power.
Well, your opposition says that the state has stepped in and has given 162 as the framework, and that cities, municipalities are not allowed to pick and choose the parts that either you use that or you don't have that right.
That's the bank's argument, but there's not a single case that says this.
Well, is there a case that says the contrary?
There are the only cases under 162 where the city has been limited in its powers are cases where the city has legislated in a manner that was completely inconsistent with the provisions of 162.
So the answer to 162 really has not been litigated. This is going to be the first case.
It has not been. Okay. And the paradigm that we have to use in order to determine this is whether there is, in fact, a conflict and whether the legislature has stepped in and said, you may not regulate in this area. That's missing, and that's the fundamental point upon which we rely.
We thank you for your argument. We thank opposing counsel for his argument. We will now move to the next case. The final case on the docket today is Earth Trades, Inc. versus TNG Corporation.
Good morning. May it please the Court. My name is John Shahady. I represent the petitioners Earth Trades and For Sealord Surety. And Your Honors, the issue before you today is a conflict that was created by the decision of the 5th District Court of Appeals in Earth Trades versus For Sealord, in which both the trial court and the appellate court found that as a result of the amendment to Florida Statute 49.128, a subcontractor and its surety were precluded from raising any defenses, including the defense of in peri delicto, solely as a result of being unlicensed. And it's the petitioner's position that is incorrect. Starting with the basis of Florida Statute 49.128, this was originally enacted as a consumer protection statute that protected a class of consumers against the shoddy workmanship of unlicensed contractors. And the cases that interpreted that originally, Castro versus Sangles, and numerous cases, determined that if the homeowner determined that, if the contractor was unlicensed, then it cannot enforce its claim against the homeowner. Now, in 2003, well, there were many amendments to the statute, but the amendment we're dealing with today is the amendment that occurred in 2003. And the impetus for that amendment was two decisions. One decision by the federal court in John B. Goodman Limited Partnership versus THF Construction, and the second was Caverner Construction versus American Safety Casualty. Both those cases held that unlicensure of one subcontractor invalidated an entire prime contract, meaning if there was a contract that incorporated the prime contract, not only was the subcontract invalid, the entire prime contract was invalid. And the order in the John Goodman case was an order denying a motion to compel arbitration, but what the court said was, and the arbitration was in the prime contract, what the court said was, because of the unlicensure of the subcontractor, the entire prime contract was invalidated, therefore arbitration was moot. The Caverner case dealt with a surety issue in which there was an unlicensed subcontractor, and the court in Caverner held that the entire subcontract, prime contract, and the bonds were invalidated solely as a result of the unlicensed contractor. As a result of that, the legislature addressed that very issue and changed 49.128 and changed it on two ways. One, to hold that only the unlicensed contractor could not enforce the contract. Secondly, a surety could not oppose its liability under a bond solely because its principal was unlicensed. And that's the essence of the amendment. The amendment did not go one step further and say, however, the unlicensed contractor, and especially its surety, had no further defenses, including the defense of in peri delicto, which is a common law defense.
Where are we if we disagree with your peri delicto position? Where would that leave us?
Well, the unlicensed contractor would not be able to oppose by any means a contract that it entered into. And it could, if this court allows that and affirms a decision, it could allow general contractors to hire unlicensed contractors knowing they're unlicensed. A situation where I'm going to explain the worst possible potential would be the unlicensed contractor could be a situation such as this where the license is pending. There's a confusion about whether there has to be a license. The license is pending. The contractor
that goes to the question of licensure. What I'm talking about is the defense of peri delicto. The person contracting with the contractor, you knew that this was pending or whatever. So that's what I'm asking about, that if we say this took out that defense in this context, where are we?
Well, the unlicensed contractor would not be able to enforce or defend its claims.
And then the surety falls into the same steps with that.
Well, I don't believe the surety does. The surety has separate defenses, and the surety should be able to, under the common law, defend its claims based on fraud, which is simply the same thing as an in peri delicto argument. The surety has separate defenses, and the surety should not be in the same position as the unlicensed contractor.
Even if the surety knows that the contractor defaulting is not unlicensed.
That's different. If the surety knows.
Well, it should be required surety should know.
Well, the surety doesn't represent to the contractor that it knows about the unlicensure. That's not a representation the surety makes. I understand that you're saying a surety should know, but in cases where a surety doesn't know.
When you underwrite bonding, it's not that they go in and say, oh, well, we don't know anything. There's underwriting that goes into this bonding requirement. And so, I mean, I'm missing the point here that this, in the suretyship field, somehow these people are just hear no evil, see no evil, that kind of, I'm blind and dumb to this. So I'm really not worried about that. I'm trying to understand the legal consequences and where it will take us.
Well, it will take where neither the unlicensed contractor or the surety will have any defenses. In this case, including the defenses set off, modification of contract, where the unlicensed contractor was owed $180,000, they'd be left with absolutely nothing. And the fact
well, that statute, you'd have to agree that if a contractor comes out and contracts with you, is not licensed, and you may owe them $180,000, but this statute would preclude the contractor from recovering from you.
Well, Your Honor...
Is that correct? I mean, that's what the statute does.
Respectfully, I don't believe so, because it does not state that the in peri delicto defense does not apply.
Without that,
I agree with you, yes.
Okay, that's what it would be.
Other than trying to collect on the contract, which the statute prohibits, could there be a claim by the subcontractor for unjust enrichment?
The case law does not allow that. And the statute says in law and equity. So there's no... I'm quoting, I think it's Wood versus Black, as a 1953 decision that says unjust... I think that said unjust enrichment was allowed, and then it was overruled. In this case, the statute says in law and equity. So no, there could not be an unjust enrichment claim by
your understanding is the statute for an unlicensed contractor is, even if they do $1 million worth of work for a general contractor, the general contractor said, thank you very much, have a nice day. They keep it, no recourse.
You're unlicensed, you're out.
Okay,
Absolutely.
So here's... we were just spent in the case before talking about, we're here on legislative intent, right? Statutory construction, not our policy of what we think should be, what's fair or not. The introductory statement of the statute is so broad. It says, as a matter of public policy, contracts entered into on or after 1990 by an unlicensed contractor shall be unenforceable in law or in equity by the unlicensed contractor.
Yes.
Now, the issue on this in peri delicto is what I thought that your defense was that the contractor knew that the unlicensed contractor, that the subcontractor was unlicensed.
That's correct.
But what I understand about in peri delicto is that how is that equal? If the violation is I can't enter into contracts or do work in the state of Florida unless I'm licensed, how is that ever going to be the fact that they also knew, and that's the allegation, that is enough to defeat the claim? The case law that I've described to you, the Castro versus Sangles, and the other cases I've described say that very thing, that if the homeowner or the contracting party knew of the unlicensure based on in peri delicto, they're both be left to their own way. They cannot, neither of them can enforce the contract. It seems like, again, this would be something that if the legislature intended to allow that type of defense, that they would have included it in the statute.
Well, respectfully, Justice Parente, I disagree. The cases I cited, specifically the Essex insurance case, says the opposite. Says when there is a common law defense or common law cause of action, where there is a statute that is in conflict with that common law defense, it must specifically describe how it abolishes the common law.
But the common law defense here is in peri delicto. And the point that Justice Parente has been making is there may be delicto, but it's not peri.
Well,
am I right?
Well, I understand that the cases I've cited and the cases that I've interpreted talk about.
I tell you, I can find something that might be described as incoherence in the case law. Would you disagree with that?
Incoherence?
Yes.
No, I would not.
You would not disagree.
It's not any of our cases.
It's not our case. I'm not talking about our cases. I'm talking about the district court's cases.
Well, again, they all state that, this is an interesting concept you've brought up, they all state that they don't go into peri delicto or delicto. They say that if you know, then you're barred. And the cases all are very clear on that.
But,
you know you're barred.
But okay, we've got to look at the statute that we've got now. And if I understand the statutory scheme now, when the subcontractor who was unlicensed entered this contract and did the work, that was a crime.
Yes, potentially a crime, yes.
Now,
misdemeanor.
It was not a crime for the contractor. At least there's nothing that explicitly makes that a crime. And there perhaps is a civil offense involved in that. But again, it's not a crime.
And the legislature, in all the history of this statute, seems to have made pretty clear that they don't want to bar the party to a contract other than the unlicensed contractor from having some ability to enforce the contract, right?
Well,
I mean, I don't know how else you could explain the way this statute has developed.
By the cases I cited, the Goodman case and the Gouverneur case, and that's what was the impetus. That's just legislative intent for that. What they didn't want to do, the legislator didn't want a situation where the entire prime contract was invalidated.
Well,
because
but the
of one
statute doesn't
contract.
say anything about that. I mean, that's all kind of a gloss, and that's not from the we cannot figure that out from looking at the text of the statute and the way that text has evolved. I mean, that's extraneous to that entirely. Well, and speculative.
No, it's not. And again, I'm using persuasive authority, but Larry Libby Construction Law Manual, that he went through in detail the legislative intent in those two cases. Now, to the extent that the court wants to agree or disagree with the persuasive authority of Mr. Libby, but that's what Mr. Libby explained was the reason and the impetus for the change.
Well, he's not in the legislature. I mean, I don't know what some commentator says about what the legislature meant to do becomes how persuasive. That escapes me.
Okay, and
he might be right.
Okay, well, again, I looked through all the legislative history and wasn't able to discern anything more than what Mr. Libby said. But again, we're talking about the fact that imperi delicto has not been specifically abolished by the statute.
But there seems, again, in that argument about where the legislature has rated knowing you're using an unlicensed contractor, which we don't want to have people do, and that subjects you to a fine, or being unlicensed and doing work, which subjects you to criminal penalties.
Potential criminal penalties,
jail,
yes.
I mean, potentially. As a matter of law, without more, how can that be equal to defeat the claim?
Well, I would just assert that every case I've cited states that it is equal to defeat the claim. So the case law that has been interpreted.
That's none of our cases.
None of your cases, that's correct.
And it doesn't really, does it go along with what in Perry, because that's different than unclean hands, from equity, right? Unclean hands means...
It's an equal defense, yes.
Okay. We're not talking about unclean, we're talking about it being equal. So here, if the contractor had said, listen, I know you don't have your license, but I can do I'll pay you half of what your rate is, because I need to get this done. And the guy saying, no, I can't do it. And said, no, I'll, whatever, I'll pay you double or whatever it's going to be. Now we're getting into encouraging somebody to commit a crime but that's not these facts.
Well, the facts are that the general contractor...
would you agree that would be that's...
Well, that's Castro v. Sangles. That's the Castro v. Sangles case, third DCA case in 1994. But in this case, the affidavit, and it's been objected to, saying it's not true, but the affidavit is that the general contractor not only knew, but he submitted recommendations to the professional board for licensing for the subcontractor, and knew the subcontractor was unlicensed.
Well, I know, but we're going back to knowing he's unlicensed subjects him to the fine. I'm saying...
I understand, and I understand what you're saying, and the law that I've cited doesn't make that distinction.
I'm concerned about the owner, because I think that when you start looking at it, the same legal principles will apply to both owners, general contractors and subs, but also to owners. And this, to me, just because an owner may be aware of that, they're in no position to protect themselves. A contractor may be, but the statute does not draw that distinction. Could have very easily said, except general contractors, if that's what they had wanted to do. But this could have, enormous impact on homeowners following a hurricane, for example. This is the kind of thing that comes out of these kinds of things. And that came out of Hurricane Andrew, for example.
Exactly, and that's the reason.
I understand. I lived through
this is more of and I understand in the consumer context, and that's my next point. My next point is that this really shouldn't apply 49.128 in the general contractor subcontractor arena.
But it doesn't say it.
I understand that, but the cases I've cited, the two cases I've cited, state for that policy. And let me explain to you why the petitioner urges that this court consider that. The Poland Kent case and the MGM construction case. This is not a situation where a homeowner is not qualified to perform professional services and requests professional services from a professional. These are two professionals that are dealing at arm's length with each other. In this case, the contractor knew the subcontractor from working at a prior job. He recommended this subcontractor to this new job. The licensing was not an issue. He relied on the subcontractor's experience and also made a recommendation to him. This is not a situation where there's a homeowner that's relying on licensing.
He also relied on him not putting the fill-in with garbage in it, too, didn't he?
Well, there's a question about that. There's a question about
but there have been factual determinations made about that.
Yes.
By the trial court.
There are. And the subcontractor's position is that it paid in excess of $300,000 to put crushed lime rock in that was beyond the scope of the contract. But the point is, at arm's length transactions, there's numerous cases around the country that state that a licensing statute should not apply in a general contractor-subcontractor relationship. And we urge this court to consider that. That shouldn't apply. Owner is one thing, but general contractor-subcontractor is totally different, where these parties know their abilities, know their reputation, and enter into contracts. And there's two issues.
Counsel, you're now down to a total of 2.5 minutes, so you've exhausted half your rebuttal time. If you want to keep going, you may. But
very simply, even if this court determines that the unlicensed contractor has no defenses, the surety has separate defenses, including lack of notice and other defenses that are personal to the surety. To allow this statute to somehow obviate the surety's defenses would be unconstitutional, as it would not allow the surety access to the courts.
I'm missing that argument because, as I understand surety law, is that you carry with you both the benefits and the detriments of whomever you are subject to protecting.
Understood. But there are separate defenses. For example, notice under the bond. If there's no notice under the bond, it does not matter if the contractor is unlicensed or not.
Well, that's not an issue here, though, is it?
I mean,
the ruling by the Fifth District Court of Appeal would encompass that and say there's no defenses.
Well, but that's not an issue in this case.
It's not an issue in this case, but it would encompass this ruling. The only
thing that really is at issue in this case is the imperi delicto defense, correct?
The imperi delicto defense and the inability to prove any of its contractual damages. Defend contractual damages, leaving a default against a surety.
Well, I mean, I got to assume that if somebody didn't pay the premium on the bond, are you suggesting that somehow is encompassed within the ruling here, that a surety could never deny obligations for any reason? I'm missing it.
Well, what the Fifth District, the opinion is stating is that the surety, if they cannot say because the contractor is unlicensed, there are no other defenses. And as far as I'm concerned, it would completely take that any defenses that the surety would have.
You mean including non-payment of bond, premium, all of those that even go to the existence of the bond itself.
And the opinion the decision didn't take that into account. And I'd like to reserve, I have 30 seconds, a little more for rebuttal if I may. Thank you.
I'll give you an additional minute.
Thank you.
May it please the Court, my name is Kimberly Ashby and I represent the respondent TNG Corporation. TNG was, of course, the general contractor in this case. And I'd like to follow up on something Justice Lewis said. This case does not involve other defenses such as notice on the bonds. They didn't raise that. You didn't pay the premium was paid. We tried this case non-jury for a full day on the challenges to the damages, on whether what was done by the general contractor to complete the work was reasonable and within the scope of the original contract, or was there a gild, a lily, or any of that. We tried all those issues.
So they were allowed, the unlicensed contractor was allowed to defend?
Yes.
So there's not that issue, and the surety also could, were they there defending?
Yes, they were defended by the same counsel and joint defense, and there was no personal issue to the surety raised other than on appeal. They said for the first time, we think our principal has committed a fraud on us, and I didn't really know how to respond to that, but this
about
isn't...
the set-off issue? Is that precluded because they can't bring a separate claim?
It is, and that's probably the harshest thing that I have to deal with, is you say, well, you know, if they did work on this other job, the Jacksonville job, also requiring a license, they didn't have any license, so that's an easy call. It was about $100,000. The expenses that TNG incurred, they spent over $200,000 just paying the people behind Earth Trades that didn't get paid, that we had to pay. And we're looking to the bond, the payment bond that we paid a premium for. Please, would you take care of these people? So that was a big chunk of even what you would consider for the set-off damages. And then the performance, we had to go in, and the garbage, there were garbage bags. I mean, when they dug a backhoe, the visual was, it was stunning. And so that's the trial judge, Judge Lawton, heard all of this testimony and decided the issue.
Earth Trades, their position was, they say imperi delicto and all your claims go away, right?
If they say imperi delicto, all my claims go away?
Well, that's their position.
Yeah.
I mean, they think, am I wrong?
Yeah, that is their claim, and Justice Perry
they say imperi delicto and demonstrate that, prove that the contractor knew of their unlicensed status. Once they establish that knowledge, imperi delicto bars any claim by the contractor.
And that's what they say. And this case is a poster child for why this isn't a floodgate that is going to encourage general contractors to go out and hire unlicensed subs.
Let me ask you a question on that. I mean, certainly this statute does not draw a distinction between an owner contracting and a general contractor contracting with a sub. But counsel argues that other states, other courts, other high courts have carved out an exception, that this statute, or one that says the same thing, has drawn, I guess out of whole cloth, an exception for general contractors, allowing a different approach. Do you agree with that, disagree with that?
I didn't see that argued, and it certainly isn't in the construct of what 489-128 is, either now or in any of its iterations.
I understand that, but he's saying other states. He's saying that other jurisdictions draw that distinction. Do you agree, disagree?
I don't know of any specific instances where that distinction has been drawn, and certainly it isn't present in 489-128. And if I can follow...
Again, I understand, because I agree with that. I mean, I'm trying to understand how other courts would out of whole cloth rewrite the statute to create an exception. I understand.
That's asking this court to legislate, and I certainly won't be a party to that. But
I mean, I understand. We're talking past one another. I'm trying to determine maybe some other courts done that?
Not to my knowledge.
Okay, that's fair enough.
I'm sorry, and I didn't mean to be evasive. On the notice issue, Your Honor, this is really where the rubber hits the road. Take your homeowner, and it could be just mom and pop homeowner. The whole issue of, well, somewhere along the line you knew I wasn't licensed, you throw that in as a defense, and now every single claim on your bond is going to trial, because that's a fact issue every time. Put that in the hands of a contractor, and I mean, general contractors in this state are trying to get traction, and all the jobs that are now becoming available, do you think they're going to want bonding? They're either 25505 public works jobs, or they're private jobs that are requiring bonds because there's so little capitalization left. You got to do it to make sure you're. And we're telling the sureties that you get a free pass if you can show any of the dozens of employees that you have or that you ever had during the context of the timing. They knew, I don't have to pay you anything. That's their case.
But for example, you do agree that if they hadn't paid the premium on the bond, that's a different story.
Totally different story.
Okay.
Yes, sir.
So is there? Your argument. I just want to make sure I understand this. First of all, did Earth Trades, were they the ones that filed the suit initially?
Yes.
Okay, so nobody's arguing that case should not be dismissed. I don't think that's being argued here.
Right.
Okay, so now we've got the lawsuit, the counterclaim is filed. And are you saying that imperi delicto could never be a defense, but just that knowledge alone is not in pari delicto?
A, knowledge alone is not in pari delicto. B, using the licensure as a defense, that's the big umbrella. And whether I knew it or I should have known it, those are subsets of the big umbrella.
Okay, so could you envision a situation, which we don't have here, where it would be equal or worse? You know, the contractor creates the subcontractor, it's the shell of the... I mean, I don't know all the possible things that could happen, but I'm sure, again, I think of Hurricane Andrew, lots of things. So we're not barring it once and for all. We simply would be saying, no, knowledge of the lack of licensure is not that cannot be brought to defeat a claim.
At this point, yes.
Okay, now the other question, I just want to make, because we were talking about set-off. They had a chance to, as to any damages that they incurred in this job, that is your client, they had an opportunity to say, no, they weren't reasonable. So again, we're not talking due process that you just can't be heard, you're defaulted out.
Right.
Right. If they said but if they were owed money from the job, and whatever the damages were, you know, we had this much damages, but there was some part of the job that had been done fine, they don't get a right to recover on that job at all.
They don't get a right to recover on the contract, which requires a license, and they didn't have one.
Okay, and again, I think you might have answered, but so there's not even a set-off, an unjust enrichment kind of set-off under where it's, because it's equity as well, you don't get it.
That's right.
The penalty is huge, which is you're subject to misdemeanor.
Right.
And you could have done $1 million worth of work. You are not going to get that money.
That's right.
Because the state's policy is so overriding in preventing subcontractors or contractors from not being licensed.
That's right. And
what if both the general and sub were unlicensed?
If the general is unlicensed, then the general doesn't have any contract rights either.
They don't have any rights against each other.
Right.
At all.
It's a perfect crime then.
It's a perfect what?
It's a perfect crime at that point.
A pox on both their houses.
That's right. And you know, from the ownership,
except for the lucky homeowner that maybe got that.
Yeah, but you know, I do look at these cases, even though this is obviously a commercial case, and say, because what this court does affects everyone, because the statute doesn't distinguish, even though we've over the years tried to get the lien statute to be commercial and non-commercial for lots of reasons, for notice reasons and other things. But in this case, okay, my homeowner has an unlicensed general contractor. Maybe they didn't know to ask. Believe me, I've done home improvements, and I've actually gotten stung by that. I'm on camera, and I hate to admit that to you guys. But you know, that's the kind of thing. When you get in a cab, do you ask the cab driver, are you licensed? I mean, really, there are times when you, the innocent homeowner, think you know what you know and you don't. You know what you could really be looking at, and I don't know that you'd see it as draconian in a homeowner setting, but if that building was constructed by unlicensed contractors throughout, you're looking at getting it raised. That building could come down, and it certainly could be red tagged, and all the repercussions, and most people are financing the construction, and the bank is now trying to figure out whether they're going to foreclose. I mean, there's a whole mass amount of things that can go wrong when somebody's unlicensed. So ground zero is the unlicensed contractor. Do you know you're unlicensed? Yeah, you do. And the current version of the statute took out the 489-128 from those local certificates, because that was making everybody crazy. Do I need a certificate in Hernando County to put up drywall? That was really starting to slam the door in too many faces, and the legislature has removed that from 489-128. So going forward, we're not worried whether I need to have a wood finish contract to put up this very lovely bench that you all sit at. We're looking at this as an underground utility contract. I'm doing French drains and tying into the sewer system. There was ever no question that this required an underground license.
So let me ask you this.
Yes, ma'am.
As I understood your answer to a previous question, there could be no set-off if you actually a part of the contract was performed correctly and they were owed theoretically money for that portion of it. Then what this statute, if that's the case and you can't get any kind of set-off even against what they end up having to pay your client, that means that this statute says you cannot bring a claim offensively and you cannot defend
it's
basically. If you can't get any kind of set-off or anything, it seems to me that you can't defend the claim either.
It's a concept of ill-gotten gains, because if I'm performing the work without a license, I can't recover on that. Affirmatively in a main claim, as a set-off, as a defense, as a counterclaim, because that's how these things tend to go, is main claim, counterclaim. You just can't recover. Now, if I want to separate out a contract that's for part of the work that doesn't require a license, and then take my shot at the part that does, I'm not. Obviously, the legislature has made this a very strong point. It's as a matter of public policy.
Except it does seem that if you really did the work well, at least you're not going to be slammed if you are able to defend and say, no, these are specious damages, so it's not like the legislature has completely neutered the unlicensed contractor. I mean, that could be draconian. Like, you can't even defend yourself.
Two things come to mind, Your Honor.
Correct, but that, again, we've already established
right.
They had the full right to defend the affirmative relief being sought by your client by saying, no, these were unnecessary expenses. They weren't occasioned by our work. Our work was excellent, even though we were unlicensed. Correct?
Yes. The two things that come to mind. One, if I had the Department of Business and Professional Regulation or the CILB with me today, they would be jumping up and down, because their whole existence is to regulate, put everybody through the same process and make sure there is a standard by which you have to meet, because these are buildings that we live in. This is a life safety issue, nothing else. I'll pick on the Florida bar. Unlicensed practice of law. This court sees quite a lot of that. I mean, you could say, well, you won the case, you should get paid. No, you shouldn't. If you don't have a license to practice law, and you're supposed to, you shouldn't get paid a nickel. And actually, I think this court supports you should be subject to disgorgement for what you've already collected, because you did something you weren't supposed to do. And these licenses are really important. This isn't... I was making fun of maybe a wood finish certificate or whatever, and like I said, going forward, I think we're not going to see those kinds of cases where, boy, that really gives you heartburn over somebody losing money. And that's what the Caverner case was about. They couldn't figure out what the local license requirements were. They never did.
If they got the license, I think they said in this case he had applied for the license.
Yes. Thank you for raising that, Your Honor. What he applied for was a CGC.
Was a what?
A CGC is a Certified General Contractor's License. That's what we have. He didn't apply for an underground utilities license. He never did. Never did.
But what would happen if he had applied for the appropriate license,
right,
and the license was at some point issued after some of the work was done?
You know what the reality is? We probably never would have known, because when he left the job, he hadn't had to pull any of the permits for the underground work, because he was still working on the site and trash and water and everything. So we never got to the point where he was actually required to go down and put his license number in.
That's why, and I was about to ask that. That's what I didn't understand. Now I get this, is that to get, the local municipality requires, license if you put up a wall.
Yeah. And we're talking the city of Hialeah, and I promise you I have no more respect for any of it. They will not put you out there.
But here it was just that they never got to the point of the work where they would have had to pull the license.
Same thing happened in the Jacksonville job. And that's why TNG never knew. They never knew. That's why we didn't raise it at the outset of the lawsuit. When they found out, Do you think we would have raised licensure if I was going to subject my license holder to an aiding and abetting if we thought we knew somewhere? Hopefully I've addressed the questions that the court has today. I really appreciate the opportunity to appear for you.
Thank you. A brief rebuttal. Justice Lewis, to answer your question to counsel, on page 21 of the initial brief, there are probably 8 cases in 2 or 3 pages that discuss the distinction between homeowner and general contractor, subcontractor. So it was explained in detail in the initial brief and in the reply brief. So that has been briefed. So that was clearly something that was discussed.
Those cases, they had a statute like we're talking about here?
Yes.
And high courts in other states have written in an exception without one in the statute?
Yes.
And on what basis?
The basis that this is not a homeowner situation where a homeowner is relying on the expertise of a licensed professional. It's where 2 professionals in the same trade are dealing at arm's length, and they're not relying on a licensure issue. They're relying on recommendations. They're relying on past work, and the courts are saying that the punitive nature of this statute should not apply where parties are dealing at arm's length and it's not a homeowner contractor
then
exception.
It just sounds like those courts are engaging in what is sometimes called legislating from the bench, because if the statute couldn't be clearer. So, and you're telling me that the statutes in those cases are identical to Florida's?
I'm not saying identical, but they are saying that if you're unlicensed, you're barred from recovery. If it's unlicensed, you're barred from recovery. I'm not saying it's verbatim, but it's the same theory. Yes. And secondly, I want to make sure we're clear. The issue of knowledge here, the cases don't make an exception for issues of knowledge and in peri delicto. And the distinction's being made here, and that there's no distinction. And we're talking about whether the general contractor knew or didn't know, and that really isn't the issue. The issue is, can the defense of in peri delicto be raised? And this court's determining, well, he didn't know about it. If it's just knowledge, it can't. That's not the issue. The issue is, should the defense of in peri delicto been allowed to been raised and should have been determined via summary judgment without being able to determine at trial if there was knowledge or if there wasn't?
And then if it was allowed to be raised and they found that you had knowledge, then your argument would be it would defeat the entire claim of the respondent?
If the general contractor had knowledge, yes.
That's all.
Yes, and the case law all the case law in Florida supports that up to this point. Thank you.
All right. We thank you both for your arguments. That's the last case on today's docket. The court now is adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.